Item number 55. Item number 55 with the main list. Today's list. Item number 55. Can this matter be taken up at 2?
Yes.
Item number 55. Can this matter be taken up at 2?
Why?
We have filed an IA. This IA needs to be considered here. We filed a fresh IA. So we are seeking some directions from this board. We are seeking some directions from this board.
We'll see when the matter reaches.
May I please, Your Lordship, I beg to mention item number 39, Lordship. Lordship, the conducting counsel, Mr. P. Hazarika, is out of station.
Mr.
P. Hazarika.
Application?
P. Hazarika. Respondent number 3 and 4, Lordship. Lordship, can it be listed after 1 week? Lord? We have taken the consent from the other side.
The request of the learned counsel for the respondent number 3, the matter stands adjourned to be listed again on 8th of June 2026.
Please, Your Lordship. I beg to mention for listing it, WTC, Your Lordship.
Motion?
No. Orders.
Give a date in the month of May.
Lordship, another case is also mentioned
For
for all orders.
May, second week.
My lord, I beg to mention for listing for orders. Next week, my lord.
May second week.
Okay.
I beg to mention item number 58, Lordship.
38.
In this case, 2 weeks time is required to file affidavit in reply, Lordship, against the affidavit in opposition filed by respondent to
Madam, I don't give this adjournment request. That is a policy which I do it here. So therefore don't ask that. You seek for a time on the account of bereavement of the senior counsel, you take it. But don't take it on the ground of affidavit in reply, which I don't allow at this hour. What do you want? Counsel appearing on behalf of the petitioner submits that the senior counsel is in bereavement and as such some time may be granted. List the matter on 22nd of June 2026.
Lordship, I beg to mention item number 5. Lordship, I'd like to withdraw this moment.
What liberty?
See, the synopsis filed by wrongly.
Forget about the synopsis. I also don't look into the synopsis. You also don't look. Argue the matter. Matter over? Argue? Well, let us take when the matter is. Yes, tell me. Did you get anything by which your reputation is maintainable?
As the ship white has been substituted by judicial order.
Substituted is okay, but then also, how do you have a right? I don't think you have a right.
As the fundamental rights, like
Fundamental right of the person is deceased.
this right has been provided by the Constitution of India
Who?
to every citizen of India.
Understood.
In
Who?
protection of lordship,
Then,
any
madam, tell me why you are not the petitioner here? Miss N. Chaudhary is not the petitioner here. You also have a fundamental right.
the legal layer as well as the
No, there's no legal as right. Legal as right will, madam, legal as right will only flow when there is an order being passed. There's no order passed.
in this point, lordship, in our earlier occasion, section 306 of Indian Section has been relied on. And in that section, there is one illustration loss. May I read lordship, that person? A collision takes place on a railway in consequence of some neglect or default of an officer, and the passenger is severely hurt, but not so as to cause death. He afterward dies without having brought any action. the cause of action dies, does not survive. Our case is the person filed after filing of the case.
Filing does not give a right.
No, Lordship, as per this, if we consider this section, that this person has no legal right, then we have the right to sue, right to pursue, Lordship. Because he filed the case during his lifetime. He approached this court under 226 during his lifetime, Lordship. Not after his death, why come before this court for his violation. 306, section 1, Lordship. And Lordship, and when this person was substituted by this court, there was no objection or anything from the respondent side of it. Since 2018, she was substituted. Case is pending. Nothing has been filed, nor any objection, nor any affidavit of opposition has been filed. 1 month before they filed one affidavit of opposition, which is signed by Lordship. Now, Lordship, police accountability. The prayer we have no.
Madam, have you taken this ground as a preliminary objection in your writ petition?
No, it did not.
File an application of it? That it does not survive. File an application. To close this petition.
Yeah, sure. On the next day.
See, all the prayers have not been survived against this violation, against the violation of the constitutional provisions, Lordship, constitutional law.
No, there's no right for you. You don't have a right.
So being a legal,
If the court would have passed it, just for example, the Assam Human Rights have passed an order in your favor. 5 lakhs. Just for example, 5 lakhs has been granted. Now, against that, you want 10 lakhs. Then the cause of action remains only to the extent of 5 lakhs. Because there is something in your favor. As of now, there is no adjudication being done in your favor for this to be continued after the death of the person concerned.
because of the Lordship, kindly consider 2014, the person approached before this court in 2014.
So-
They have filed affidavit of 26. So Lordship, this is not the fault of the petitioner who died.
Madam, you filed that.
I felt.
Miss M. Hazarika appearing on behalf of the respondent number 11, respondent number 7, no? 7 submits that the instant writ petition cannot be proceeded with taking into account that the cause of action for the present writ petition no longer survives upon the death of the original petitioner. Full stop. This court duly inquired with the learned senior counsel as to whether such plea has been taken by the respondent number 7 or any of the respondents in the instant proceedings. The learned senior counsel submits that this is a plea based upon law, and as such, there is no requirement for filing any pleadings in that regard. However, as a matter of abundant caution, the respondent number 7 would like to file an additional affidavit taking up the said plea. It is the opinion of the court that an opportunity in that regard should be granted. Accordingly, list this matter again on 21st of May 2026. The affidavit be filed, additional affidavit be filed on or before 11th of May 2026, liberty given to the petitioner to file reply thereagainst on or before 19th of May 2026. The said aspect would be taken, the said preliminary objection would be taken up for hearing on the next date. What is this? Non-payment? What has happened?
Order, last order take 11 hours. Order of the right, one of the right.
Then
Sir, I represent that the letter replied. Representation in page lordship 12.
page,
Representation in page 10 lordship.
12:8.
10, page 10.
Mr. Counsel, Government Counsel, kindly call Miss R. Deka appearing for the Water Resource Department. We'll take it over.
It is also for non-compliance of the judgment and order dated 23/7/2025. Judgment is at page 12. And the relevant portion is at page 15. Para 7.
Revenue, anybody from revenue? Call Miss one of the revenue counsels.
3 also sir. 3 also sir.
You open local revenue at the matter. I think. Oh,
4 also. Yeah.
Can you pass over for time being?
why?
Senior is in another court.
You want to undo, somebody wants to withdraw?
Withdraw, yes, Lordship.
You want to withdraw this? What is the matter about?
A grief against the SOP lordship that was
You're
issued
not
by the
challenging the SOP.
lordship regarding cattle transportation lordship.
Lordship, the synopsis of another case has been attached. Lordship, the synopsis of this case.
Madam, we are not concerned with the synopsis. I don't read the synopsis. What do you want here?
Withdraw.
Withdraw.
Huh?
Withdraw.
You want to withdraw the writ petition without liberty.
With liberty.
Why liberty? Synopsis cannot be a ground for liberty.
I may allow to amend. Lordship.
Amend what? Amend what? You don't have to amend the petition. You notice making it returnable on 1st of June 2026. Mr.
J.K. Goswami Lordship.
J.K. Goswami accepts notice on behalf of the respondent number 1 and 2.
Yes.
Mr. So-and-so accepts notice on behalf of respondent number 3. Extra copies of the writ petition be served upon them during the course of the day. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities, more particularly the respondent number 2, in not providing the certificates as is required under Rule 47 of the Transport of Animal Rules 1998 and Rule 96 of the Rule 47 and Rule 96 of the Transport of Animal Rules 1978 by the respondent authorities. And it is under such circumstances the present writ petition has been filed. The respondents herein are directed to bring on record the stand as to why the petitioner have not been provided with these certificates by filing an affidavit on or before 28th of May 2026. Full stop. The learned counsel appearing on behalf of the petitioner submits that there has been certain mistakes in the synopsis and would therefore like to file a fresh synopsis in the matter. Full stop. Liberty is granted to the counsel appearing on behalf of the petitioner to do the same within 7 days. Don't withdraw. Oh, wait. Miss Ardeka, I think just 1 minute. Miss Becca, kindly give a copy of the contract. Give it.
Yes, today.
Give it now. Yes. You see, there is a direction passed by this court to make the payment within 4 months.
Yes, Your Lordship.
Okay.
Yes.
Now, this direction has been given to the respondent number 4, that is the Chief Engineer, Water Resource Department.
Yes.
Just kind of find out what is the present situation. This is an application filed alleging willful and deliberate violation to the order dated 5/4/2025 passed in WPC number 1205/2023, whereby there was a directions upon the respondent number 4, that is the Chief Engineer, Water Resource Department, to pay the amount of rupees 3,88,722 to the petitioner within a period of 4 months. It is the further case of the petitioner that the said order was served upon the respondent number upon the Chief Engineer, Water Resource Department on 12/8/2025. And in spite of the passage of 4 months, the payment have not been disbursed to the petitioner. And it is under such circumstances, the present contempt application has been filed. This court have requested Ms. Ardeka, the learned standing counsel of the Water Resource Department, to obtain instructions as to whether the order dated 5/4/2025 in WPC number 1205/2023 has been complied with, and if not, what is the present state of compliance? Full stop. A copy of the contempt application be served upon her during the course of the day, so that so that Ms. Ardeka, the learned standing counsel of the Water Resource Department, is in a position to obtain the necessary instructions. List this matter again on 1st of June 2026. In the meantime, the registry shall also show the name of Ms. Ardeka in the cause list. Huh? 6.
My lord, this matter, my lord, regarding abrupt disqualification of my bid.
What?
And disqualification regarding the bid in respect of the
Withdraw
NIT.
such disqualification and initiate a fresh tender process.
Yes.
What are you challenging?
Challenging, my lord, I submitted my bid as well as financial and technical bid. But so far my technical bid is concerned, that has been disqualified.
Why?
And that has not been informed. But therefore, my lord, I made a representation on 4/4/2026, Annexure 4. Now, my lord, recently on 22nd of
Where is it mentioned that it has been disqualified?
Yes,
Which document?
I heard from reliable source.
No relevant
This is-
source.
Now inform me, my lord, on 22nd of this month, that on what ground I am being disqualified. Now, it was not furnished earlier. And that is, what is the ground here narrated? But so far my bid submission, everything was there, my lord. So far my lord, an Excel 3 is concerned. All, this was my lord, online submission. They are saying, my lord, that
Now you know this.
on 22nd of this month.
Understood. So
I
now
come to-
what remains?
But this respondent number 3 says that work order has yet not issued.
I'm not concerned to that
But
effect, but
question
Mr.
question
K.
is that
Bhuiya,
is to be
no,
taken-
Mr.
that is to
Bhuiya,
be taking into account whether
Mr. Bhuiya, unless you challenge this document, you don't have a writ petition there.
But,
You see, there is a disqualification, you heard about it. Now the reason has been given. So when the reason has been given, you have to assail that these are the reasons which actually are perverse. Where is it?
Well, I will file additional affidavit.
You want to file an additional affidavit, but your entire case will change.
But no, my lord, I have narrated because lordship kindly have.
No, tell me. No, tell me. Where have you narrated that you have a single similar work with itemized quantity, qualifying quantity in a year? Where have you narrated?
Paragraph 6, I have narrated only disqualified on technical ground.
No.
This is also technical ground.
You have to categorically say that these are the cases. You want to file an additional affidavit, file it. But the fact remains, by way of an additional affidavit, you cannot have a substantive challenge.
I will bring this on record. That will be sufficient
No.
because paragraph 6 is there.
It is not so because of the fact that you have to challenge this particular notification. How do you challenge it by way of an additional affidavit? Tell me. Give me a good idea. How do you challenge by way of an additional affidavit?
That's right, my lord. But I have narrated, declared disqualified on technical ground. This is also technical ground. And it has not assailed.
You have
But-
filed the writ petition on 6/4/2026 on the basis that you have come to learn that you have been disqualified on technical grounds. This is it. Then you filed some RTI or something and you have been informed by the communication dated 22/4 what are the reasons. Now these reasons are you have to assail. How do you assail it?
Lordship, then this petition not necessary to withdraw. I'll find fresh matter that will be take with this petition.
Shall I? We dismiss your petition then? No.
This
We
will-
dismiss
this
it.
will remain. This
No,
will
it
remain.
won't.
And
Let us dismiss
file-
your-
File fresh
There's
or
no.
otherwise withdraw with liberty.
No. That is what? Withdraw with liberty in view of this and file a fresh one.
This
That is what I'm saying.
so far,
Mr. Heard, Mr. K. Bhuiya, the learned counsel appearing on behalf of the petitioner. The learned counsel appearing on behalf of the petitioner has submitted that as on the date on which the writ petition was filed, that is on 6/4/2026, the petitioner was not aware of the reasons as to why the petitioner's technical bid was rejected. However, by the communication dated 22/4/2026, the petitioner has been informed by the executive engineer PWRD that the petitioner's technical bid has been rejected on account of not producing any document having a single similar work with itemized quantity, qualifying quantity in a year, or multiple works of similar nature with itemized qualifying quantity bracket cumulative in a single year. The learned counsel submits that the reasons were assigned in the said communication dated 22/4/2026 is perverse, and the petitioner would like to challenge the same. Under such circumstances, the petitioner therefore submits that the petitioner would like to withdraw the instant writ petition. The learned counsel submits that the petitioner would like to withdraw the writ petition with the liberty to refile by challenging the communication dated 22/4/2026. Taking into account the above submissions, the writ petition stands closed on withdrawal. Liberty, however, is given to the petitioner to refile by challenging the communication dated 22/4/2026, if so advised.
Lordship, against the word rejected, may kindly include disqualify. They are saying this is disqualified. I mean disqualified.
Technical qualification was rejected.
Obvious question.
Your Lordship, my senior counsel is engaged in another court.
Who is your senior counsel?
Mr. B. Chetri. Can the matter be taken at 2 p.m.?
Absolutely no. What is this, Mr. Goy?
Lordship, that I'm
Oh,
MFL
yeah.
of license was not issued.
Huh?
IMFL on of stop was not issued in favor of the prisoner. There's some public complaints are there. No?
Okay.
No.
So he wants the license to be
Yes.
issued.
Yes.
Okay. Okay, let your senior come and we'll dismiss it, taking into account that you have slept over the rights from 2023 and coming after in 2026. If you had otherwise said, I would have issued notice, but no, with your let your senior come, we dismiss it.
There's a lordship matter related to non-payment of contractual work. That is amount 11 lakhs, 2,533.
Period for what?
Not.
20, 21, 22, 23.
Into. Your lordship 20, 21, 22, 23. And 23. We
Issue
have,
notice making it returnable on 27/2026. Mr. So accepts notice on behalf of the respondent numbers 1, 2, 3, and 4. Extra copies of the writ petition be furnished to. How is respondent number 1 and 2 are connected? They are connected, no? Petition 1, 2, and 4. Extra copies be furnished during the course of the day. The petitioner herein has filed the instant writ petition being aggrieved by the non-release of an outstanding amount of rupees 11 lakhs 2,533, which the petitioner claims to be entitled on account of the various work orders issued, which have been cumulatively enclosed as Annexure A series. The respondents herein are directed to bring on record the stand by filing the affidavits on or before 15th of July 2026 as to whether the petitioner is entitled to the amount so claimed, and if not, what as to whether the petitioner is entitled to any amount. Yes, Mr. Bhatti.
My lord, my amount of rupees 1,52,670
Huh?
was deducted. A sum of rupees by the IOC, my lord. A sum of rupees 1,52,670 was deducted from my account, my lord. Your lordship may come at page 57, my
So you 1,52,000 has been deducted from your account.
account.
So you have asked for reimbursement of that.
Yes, reimbursement of that.
If you
Apart from-
notice making it returnable on 15th of June 2026. So and so accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the writ petition be served upon him by tomorrow. So it is the case of the petitioner that an amount of rupees 1,52,670 was deducted from the petitioner's account.
Account.
Account,
PAD.
huh?
PAD.
What is that?
pre-audited debit
Huh?
balance account.
Pre-audited debited balance account
Pre-audited
by
debit-
the respondent number 3. For no good reason. And it is under such circumstances the petitioner has approached this court seeking a direction upon the respondent authorities to reimburse the said amount of rupees 1,52,670. The respondents herein are directed to bring on record their stand by filing the affidavit on or before 10th of June 2026.
My lord, I have limited prayer, interim prayer now. That in the meantime, they may kindly be directed not to deduct the amount without giving me the intimation or the opportunity of doing fine.
Let us see when it is done. Next time.
My lord, it is very limited one.
You see, Indian Oil Corporation would not do unnecessarily. There will be some. As of now, this is not a case made out. It's a case of money, so you have lots of money.
But
What is this case?
Please, Your Lordship.
Ah.
So here in this matter, Your Lordship, the petitioner was awarded with the work for construction of 4 numbers of additional classrooms, Your Lordship, on 21/10/2024, Your Lordship.
Ah.
If Your Lordship has a perusal at Annexure H, page number 58, Your
Then what
Lordship.
happened? You have not got the money,
Yes, Your Lordship, the amount has already been sanctioned by the mission director, Your Lordship.
but
assessed
they are
it.
not paying it.
Yes, Your Lordship.
Why?
In this regard, Lordship, we have to take instruction why they have not released the
Issue notice returnable on 17th of June 2026. Ms. N. Chaudhary accepts notice on behalf of the respondent numbers 1 and 2. Mr. So-and-so accepts notice on behalf of the respondent number 3. Extra copies of the petition be furnished by tomorrow. It is the case of the petitioner that the petitioner was awarded a work order by the
Director of Education, Your Lordship.
by the respondent number 2 for construction of 4 numbers of ACR bracket G+1 bracket close at Holbury Higher Secondary School, Baksa, under BTC Kokraja, which was funded by the respondent number 3 for the year 2023-24. The petitioner duly completed the work, and it is the further assertion of the petitioner that the respondent number 3 have also paid the amount to the respondent number 2, but the respondent number 2 having not released the amount, the petitioner has approached this court by filing the present petition. Taking into account the above, the respondents herein are directed to bring on record their stand by filing the affidavits on or before 8th of June 2026. The respondent number 3 specifically is directed to file an affidavit that apprising this court as to whether the amount in respect to the contract have been disbursed to the respondent number 2. The respondent number 2 is also directed to mention in the affidavit as to whether the amount has been received in respect to the contract from the respondent number 3, and if so received, why the payment have not yet been disbursed to the petitioner.
May I submit, Your Lordship, with respect to respondent number 2, the amount has been sanctioned to respondent number 1, Your Lordship, the principal secretary, Your Lordship, ETC, Your Lordship.
Okay, respondent number 1. Respondent number 1 of
Much okay.
the amount has been sanctioned to the respondent number 1.
Yes, Your Lordship.
Yeah, go can you take hold of it, huh?
Much okay.
Contractual bill, family से page 20 में is the completion certificate.
Completion when?
Completed mention in the year 2013. Date of completion 22/11/2013.
How much amount?
19,53,536. Another 9 lakhs already sanctioned, but due to fault of the respondent, it was not done by the petitioner টাকা NBC page 27 টাকা endorse name not wrongly printed in the check.
But why work is completed in 2013, you have approached this court in 2026?
But completion certificate issued on
2013.
18 mal.
So what? After 2018, why after that another 8 years?
2018 malot
Go to the civil court. We are not going to entertain this type of petition. Sorry. They will lose the file. They must have lost the file. Isn't it? No valid defense. We dismiss it. Invoke or no. Judgment to be dismissed. Or withdraw it. Go to the civil court. Withdraw. Mr. K.R. Padgiri, the learned counsel, heard Mr. K.R. Padgiri, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so, who appears on behalf of the PWD, as well as for the finance. Full stop. The learned counsel appearing on behalf of the petitioner submits that taking into account that there are facts which are would require, there are issues which would require factual adjudication. The petitioner would be well advised to approach the competent court of civil jurisdiction. He therefore submits that he would like to withdraw the instant petition without prejudice to avail remedies before the competent court of civil jurisdiction. Taking into account the above, the instant petition stands closed on withdrawal. Stop. It shall be the withdrawal of the instant petition shall not prejudice the petitioner to avail remedies before the competent court of civil jurisdiction if so permissible under law. Right. Mr. Gogoi, kindly get hold of a revenue department counsel, please.
May I please, your lordship?
Yes, why? This is another petition file.
Yes, lordship.
Why?
Lordship, because my amount has been already been deducted without giving me the opportunity of the ARV slips, your lordship. My amount has been deducted, your lordship, from the paid account of the petitioner, your lordship.
So
Lordship, may I brief the matter, your lordship?
you like to file litigations after litigation.
No.
Your litigation is there.
No. They have
What
come
is
for
that?
this time. Lordship, this is a different case, lordship.
I know that. This is the one which is there. That day I didn't pass us any interim order. I vacated the interim order. That
Yes,
was
lordship.
pertaining to suspension. Now, from where will they deduct from your paid account? You are not operational.
No, the paid account is functioning, your lordship.
But you are
It
not
has nothing to do
operational.
with the suspension, your lordship. Yes, it is a different matter, your lordship.
There's another different distributorship or that same one.
Saved. Vacation fund, holidays. What has happened is that IOC, if for example, they cylinders, the petitioner as a contractor.
Why you are appearing in this matter? Then why didn't you appear in the earlier matter? So you appear out there or that counsel appeared?
Six, I said six.
There's somebody else. So they have a standing counsel, So you have standing counsels or therefore from next time onwards we know that they are standing counsels.
There are certain branches in the IOC.
And I retail how many persons are there? Okay.
As far as I'm aware, there are other councils also cooperating.
Okay, now what do you want, Mr. Das?
Lordship may come to lordship. It's a similar case. Lordship has already had an opportunity of.
Okay, same order.
Lordship may come to page 65.
We have the same order on that date, on the same date.
Lordship, may come-
Upon our fixed rules.
into same order.
What? No, just now I passed an order in.
Lordship, that in that case, lordship, item number 6, lordship, They have not disclosed on what basis the deduction has been paid. But I know, Lordship, on what basis the deduction has been paid, your Lordship. Lordship may come to page 65, your Lordship, once. Lordship has handled this matter, Lordship, once. Lordship, this is regarding a similar distributorship, Lordship, Sudipta Kalita. Lordship may come to page number 67, Lordship.
Yeah, they have deducted already.
Yes, Lordship.
So we'll see when the matter is taken up on the next day. Let them file their affidavit.
Lordship, no,
Now.
it can be disposed of, Lordship, on
Huh?
on the similar direction, Lordship, because in a similar case,
Huh.
Lordship, they have, the order has been issued, Lordship, just before the vacation. Can be disposed of on the same line.
No, not this type of orders. Why should we pass this type of orders? We'll issue notice now. Let us see. Wow. These are, here, there is a direction of returning. How do we return him today?
Lordship.
You see, you are seeking for a direction for returning that 2,31,000.
Yes,
How do I pass an order to that effect?
in that case also, Lordship.
No, similar case also, we are not looking at. We are issuing notice legally.
Lordship, that
And
has
as
been applied,
regards,
Lordship.
should not be issued for so-called notice dated so and so.
Comes to
So-called notice, what is this? 19?
19, Lordship, that is the,
Where is the so-called notice?
that is page 27, your Lordship. I have some disputes with regard to the amount, your amount.
Have you replied to the so-calls?
Lordship, I have asked for them, their ERV slips, Lordship, in light of those judgment that Lordship has passed, Lordship. Lordship,
And have
may
you
come-
got the ERV slips?
No, Lordship, they have not even asked. No, Bharat, the fact that they have got ERV slips. And the earlier application, the party has come the first time they, so now the Lordship directs them within a period of, for example, 10 days. Go visit our IOCL offices and examine the slips, thereafter further reply. We obliged to them.
Is the year were not signed either by the transporter so and so. On receipt of the petitioner may be separate replies on different date. Considering the above so and so dear. Okay, we do one thing. We issue notice. In the meantime, you provide him the ERB
We
slip,
do that,
matter of word, and then you submit your reply.
Lordship.
You submit your reply, because here the question is for refund also.
Refund is also.
So refund, we can't keep it now. We have to
Exactly,
execute
Lordship.
that.
For refund, you have to adjudicate, Lordship.
So therefore, this adjudication will remain. But as regards the so-called notice, you are not in a position to submit because you don't have the ERV.
I don't have the ERV.
So therefore, within this period, you provide within 30 days.
We'll do that.
Okay.
In fact, the last communication that has come from the IOCL in this regard was at page 51 on the month of July last year. And the deduction has happened this.
Now we are not interfering with the deduction. You see, you have asked for a show cause. I'm not interfering with the show cause proceedings. You provide him the ERB slip, let him reply, you adjudicate the show cause procedure. Now the question as to whether it is to be returned or not, that is the only paragraph 1 we are considering, not others. Others are not. Issue notice making it returnable on June 19th, 2026. Mr. M. Sharma accepts notice on behalf of the respondent numbers 1 to 6. 1 to 6. Extra copies of the writ petition be served upon him by tomorrow. First, the petitioner herein have assailed the deduction of rupees 2,31,338 by the respondent IOCL authorities from the PAD account of the petitioner. On the ground
Market.
that the said actions have been taken without giving an opportunity of hearing to the petitioners. The petitioner have also assailed the show cause notice dated 19/2/2025 issued by the Deputy Manager Plant North Gauhati Bottling Plant Indian Oil Corporation Limited on the ground that the said show cause that those such so-called proceedings have been issued, but without providing the ERB slips, the petitioner is not in a position to submit a substantive reply. Isn't it?
Yeah, yes.
First, this court have duly heard the learned counsels appearing on behalf of the parties on the interim prayer. First, this court observes. This court inquired with Mr. M. Sharma, the learned counsel appearing on behalf of the respondents, as to within what time the ERB slips could be provided to the petitioner, so that the petitioners are in a position to file the reply. Mr. M. Sharma submits that within 10 days, such ERB slips shall be submitted, shall be furnished to the petitioner, on the basis of which the so-called proceedings, so-called notice dated 19/2/2025 has been issued. Taking into account the above, this court directs that in the meantime, the respondent authorities shall provide within 10 days from today the ERB slips, which on the basis of which the show cause notice dated 19/2/2025 have been issued to the petitioner. Upon the petitioner approaching the respondent number 5, respondent number 5,
3 and 5, Your Lordship, because 3 is a check minute.
he has issued the show cause
Yes, he
notice.
has.
Upon the respondent number 5, approaching the respondent number 5 with a certified copy of the order. Insofar as the deduction of rupees 2,31,338. No, 10 days, full stop. Upon receipt of the said ERB slips, the petitioner shall submit a reply within 7 days thereafter, and it shall be open to the respondent authorities to decide the said show cause proceedings. In the meantime, full stop. Next. Insofar as the deduction made of an amount of rupees 2,31,338 by the respondent authorities as alleged by the petitioner, the respondent authorities are directed to bring on record their stand by filing their affidavits on or before 12th of June 2026. Liberty given to the petitioner to file reply thereagainst.
In the meantime, Lordship, no further recovery.
No further.
That is, Lordship.
You have got some money, don't worry.
No, Lordship, if the recovery takes place, Lordship, that will be hampered the case, Your Lordship.
It would not. You'll get whatever. Any deduction so made during the pendency shall be subject to the outcome.
Lordship, one more thing, Lordship. I filed this petition on 28th, Lordship. On 21st, Lordship, another amount has been deducted. That's the additional affidavit, Lord.
How much?
Lordship, that is, Lordship. 2,20,322. Lordship, that may be added.
And then 2,32,000 and 2 lakh.
2,20,322.
There's one small solution. The order. It will be more convenient for the party. That's what other prediction. Instead of the voluminous signature might not be one slip flow. Also a lot of slips. We help the petitioners for the then sit down.
Therefore, I have given him within 10 days from the date the certified copy is served. He will go there. Then you do it. Mr. Dutta, find out why payment has not been made. This is an application filed alleging willful and deliberate violation to the order dated 23/7/2025 passed by this court in WPC number 6859 of the 2024, whereby there were specific directions issued to the respondent authorities and more particularly to the Principal Secretary to the Government of Assam Revenue and Disaster Management Department to complete the entire exercise as directed at paragraph number 7 within a period of 6 months. It is alleged by the petitioner that the said exercise had not been carried out in spite of the fact that the certified copy was duly served on 16/9/2025. This court therefore have requested Mr. S. Dotto, the learned standing counsel of the Revenue and Disaster Management Department, to inquire from the respondent authorities, more particularly the Principal Secretary of the
Additional chief secretary.
additional
Chief secretary.
from the Principal Secretary, bracket, presently additional Chief Secretary of the Government of Assam Revenue and Disaster Management Department as to whether the order dated 23/7/2025 passed in WPC number 6859 of the 2024 have been complied with or not. Full stop. And so Mr. S. Dotto shall also inquire as to what is the, shall also inquire that if in the circumstance the order have not been complied with, as to what is the stage of compliance. Full stop. A copy of the instant contempt application be served upon Mr. S. Dotto, the learned standing counsel of the Revenue and Disaster Management Department during the course of the day. List this matter again on 3rd of June 2026. The name of Mr. S. Dotto be reflected in the cause list. The second matter, the third
Same.
matter is also same.
Yes.
Another matter.
Yes.
Same order?
Same one. Normally the order dated is different.
Order is
So,
same.
sorry, order dated same, petition number is
I look.
much. Okay.
3 and 4 is same, similar order. That's what is the review you asked?
Lordship, here at the beginning, I would like to state that, Lordship, 9 review petition have been filed. Only 6 have been listed.
Forget about that. Let us dismiss the 6, then the 3 would not come.
On the first day, Lordship has directed for listing all the cases.
Forget about that. Now argue the matter.
Yes, ma'am. Lordship, may kindly take up.
Why do you want the review?
Item number 15, Lordship.
We have taken up one matter. Item number
This
13.
will be 13, Lordship.
What is the ground of review?
Ground of review is that, Lordship, here the assessing officer issued an assessment order against which the assessor went before the revisional authority. And there, in the assessment order, Lordship, the firm, Lordship, they had made interstate sale with some of the bonded warehouse of Arunachal Pradesh and other state. And we found out that the license of one of the bonded warehouse has expired during the period of transaction as reflected in the document. Lordship has, and we came before Lordship on the basis of a circular, which Lordship held that it does provides only the guidelines for VAT audit assessment and not for the anything for the revisional authority. And in the revision proceeding, Lordship, the SSE brought out one document that the expiry of the license of that bonded warehouse was renewed. And Lordship also held that there was no further inquiry by the department on that basis. And accordingly, Lordship directed for reassessment as decided by the revisional authority. While we went for revisional reassessment, Lordship.
Not reassessment,
Assessment, Lordship. Lordship, we found in the record that the predecessor incumbent officer had written a letter to the excise department in the Tinsukia where the transaction was there to give the documents by which they had made those transactions, basically the export license and everything.
Mr. Shaw, you have to understand. There's the revision of what was the case? The case was, you have made certain assessment. Against that, he has filed a revision. At the time of admission of the revision, there were certain amounts directed to be paid. They paid. After that, when the revision authority held in their favor and set aside the assessment, the amount was to be refunded back. That was the direction.
Yes.
So therefore, they came up before this court and filed a petition that, look here, neither they have carried out any assessment or whatever may be, nor refunded amount. Okay. In the meantime, while the matters were going on, this petition was going on, you filed various petitions
Yes.
challenging the revisional order. Now, all these, the revisional order was upheld by this court, by this imperial judgment. We have not filed a challenge to that order. Challenging the 26/2/2020 revisional order, which was dismissed, you have assailed before the division bench or not? I don't know. No,
Not of,
but the fact.
That was not done.
No.
Lordship,
So
because-
therefore, the challenge to the order dated 26/2/2020, by which the revisional authority had set aside the assessment orders, have been done. Okay.
Lordship, we had approached the Board of Revenue within the limitation period. As there was lack of quorum in the Board of Revenue, we
So
came
you
before.
came up before this, you have challenged it,
Yes, Lord.
but I have upheld this order of 26.
Yes, Lord.
You have not challenged, therefore, you have
we have
not
not
gone to
gone
the
in the
division
higher
bench.
court.
So therefore, the order of 26/2/2020, which was passed by the revisional authority, has attained finality. Now, therefore, there is a requirement for you to carry out an assessment as directed by this court. This court further directed that apart from that, if after assessment any amount is found payable,
Yes, Lord.
then you refund along with interest at the rate of 9% from 8/5/2021, because that is the date on which he had deposited the revision petition. Okay, now let us see what you say, that fresh materials have come into light.
Yes, Lord.
Now, if it is a fresh material has come into light after the assessment order also, you can carry out the reassessment or take into account those fresh materials while carrying out the assessment.
Lordship,
It may be wrong at best.
Lordship, the basic thing is that the revisional order, the basis of that revisional order on the document later given by the government of Arunachal Pradesh, that the license was renewed or that bonded was on subsequent inquiry, Lordship, the government of Arunachal Pradesh has issued a letter stating that the letter was never issued and the memo number relates to a different subject, Lordship.
Understood. So then take those into account and carry out the assessment. It may be assessment may be wrong. Again, they will challenge.
If Lordship,
Why should I say anything?
yes,
You have understood.
I have
So
understood.
the review petitions are to be withdrawn. Carry out. Otherwise, we do that. These material which you are there, that material cannot be taken into account by this court now. So therefore, we reject. Go ahead with the assessment. You know what to be done. You see, what are the opportunities you are available? You carry out the assessment. Thereupon, you can again carry out reassessment on the basis of that material. Why you're disclosing your cards today?
If Lordship,
Why?
if someone hand,
I am
then
not
Lordship,
here
then
to
it
give-
can be done.
I am not here to give advice.
Lordship,
I
some
understand
handle-
what is it.
Lordship.
I understand. Your case now is, then look here. After this, we could find out certain document by which the government of Arunachal Pradesh said that this was document was not issued. This is your case. Now, therefore, you carry out the assessment, you can very well reassess also under the provision of 40. This is VAT, na?
Yes, sir.
40, you can reassess one. Or while carrying out the assessment, you can you see, there is a direction to carry out an assessment.
Yeah.
So at the time of assessment, you can very well take up other materials also.
Yes, Lordship, because it's a new
It
process.
is a new process. You are asked to pass such orders. So it is not that you are confined. If any other materials come, you can very well edit. Now, why you are asking for a review?
Yes, sir.
Withdraw. Or dismiss.
Lordship may, if short time, Lordship may, I will have to discuss with the department, Lordship.
So dismiss. No.
I will do
The
that.
moment I dismiss it, the problem here,
The
I have to
problem will
mention
arise.
about your ground. You see, I have to mention about your ground.
Yes,
The moment I mention about your ground, then
that will get.
you
it.
are in a position to do, you have a problem out there. Your opportunities which are there, many pronged. As of now, you can take this particular document for at the time of assessment. At the time, this document can be taken at the time of reassessment.
It's there. Lordship.
All these things will be closed. Anyways, I think you are filing a review. One order, one line order you can do. Or Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. R. G. Rahul appears on behalf of the respondents. Anybody else? No.
No.
The present batch of review applications, how many cases have come?
6, Lordship. 6 in.
Essayed, have sought review of the order dated, of the judgment and order dated
21/1/2025.
21/1/2025, passed in WPC number 4240/2022. Full stop. This court has perused the grounds of review, the ground on which the review has been sought for. And it is the opinion of this court that no grounds have been met, and it is, no, it is a trite principle of law that for the purpose of exercise of the review jurisdiction, three conditions, either of the three conditions have to be satisfied. That is, number one, that the judgment and order so passed, that there is an error apparent on the face of the record while passing the judgment and order. Number two, when new materials comes to light, which which the review petitioner could not place at the time when the impugned judgment and order was passed in spite of due diligence. And number three, or semicolon, or number three, for sufficient reasons. First, the ground on which the review petition had been, the ground on which the instant review application had been filed. The grounds on which the instant review applications have been filed, in the opinion of this court, do not satisfy any of the three conditions for reviewing the judgment and order dated 22/2026.
21/1/2025.
21/1/2025, passed in WPC number 4240/2022. As well as along with the connected matters. Under such circumstances, the instant batch of review applications stands dismissed. Reject.
Lordship, let me withdraw it then. If Lordship, a dismissal order will have an impact, Lordship.
Stands rejected without prejudice to the contention so raised in the review application. Give the names of the other three. Give a mention memo in respect to the other three on the review petitions. We'll close it today itself by the same order. You got my point, how it is to be done. Yeah. Yes, the order me. What is this?
8,50,000, my lord.
What happened? No further affidavit has been received by the respondent of 4 and 5. We are paying for whom? Huh? Respondent number? You have to get the money from whom?
From the matter 4,
Huh?
4, West Golpara College. Principal.
So, how can we initiate action upon them?
Because fund was released from them.
What is
That's
this
it.
college?
Provincial High School, West Golpara College.
So,
Because fund
High
was
school.
released from their part, that is why.
what was the period of when it was filed? Where is the work order?
2020.
Huh?
2020.
Work order is where?
Yes, my lord. That is, my lord,
Where is the work order? By the construction, when we need the undermentioned works have been allotted you for construction of women's hostel under the UGC grant.
yes.
What?
Page 12.
This type of contracts we cannot allow. How much amount?
8,50,000.
For one, from one hostel,
Yes, my lord.
it is only 8,50,000.
Yes, my lord.
So cheap.
The year 2019.
The 19 it was so cheap.
That is mentioned. They have in representation also it is mentioned.
Where is the amount fixed? Huh?
Amount, my lord, fix page 18, my lord.
What is this?
This is representation. And but that
Where is
amount,
the admission on their part?
that is page, my lord, 17 also is mentioned.
What?
Page 17 and next are 5. Proceeding of conciliation meeting arrived at between the principal West Golpara College, Ambari, and the component store of Ali. Baladmari Sor Golpara sons held on so and so. The conciliation arrived at between the parties in presence of the labor officer, conciliation officer, member so and so. Devan Sharma, he was the principal now, the end, my lord. Short recital of the meeting. The meeting discusses the complaint submitted by Torapalli, which was forwarded by the additional deputy commissioner relating to non-payment of the outstanding wages for construction of the administrative building, boys hostel, canteen, etc. at West Golpara College, Ambari, to be complained by the said college authority. And
Why have you not filed affidavit? You are paying for respondent number 4. Who is paying for respondent number 4? Yes, why haven't you filed affidavit? You are the principal. 5 is the president.
Yes.
So it is the same. 4 and 5 is same. Why haven't you filed it? So you are not appearing for respondent number 5. So this is a very old matter. And why you have not filed affidavit? You are paying for respondent number UGC. UGC is not intimated. UGC has no business out there. Who is paying for the higher education department? What is this wrong with this? And why is the conciliation officer doing anything? This is where is the labor dispute, Mr. Counsel?
but matter was taken up
Why? He
because
has no jurisdiction as regards non-payment of dues.
but
This type of litigations,
Yes.
I think, will go to the civil court.
already amount is old, my lord. That is why, my lord.
Where?
Well, that at the relevant point of time, that was, my lord, done on 21st March 2018.
No, these documents I am not satisfied with. I think this matter should go for another 2-3 years, then one fine day we dismiss it.
And my lord, also
No, we
page,
dismiss.
my lord, 24. Page 24, kindly peruse your
Not
lordship.
24. No matter of the.
To the principal, completion of construction,
What
settlement of
is this
building,
24?
sport interest, so and so,
The
women hostel.
principal by who is your education officer.
Yes,
So and so accordingly, the college is to complete the construction of their courses. Unless strict of the thereafter some. Now, how does it matter? How there is an agreement? Where is your agreement?
yes.
There's no agreement, nothing. Not satisfied. Go before the civil court. Heard, Mr. We dismiss it. Heard, Mr. H. the learned counsel appearing on behalf of the petitioner. Higher education, Mr. D. Upamanu appeared for respond number 1. Ms. So-and-so appears for respond number 2. Ms. So-and-so appears for respond number 4 and 5. The present petition has been filed by the petitioner claiming an amount of rupees 8,50,000 from the respondent numbers 4 and 5. Full stop. The materials which have been placed before this court do not show and materials which have been enclosed to the writ petition do not prima facie goes to show that the petitioner have been able to make out a case for a direction for issuance of a writ upon the respondent authorities, more particularly the respondent number 4 and 5, for passing, for releasing the amount as claimed by the petitioner. Full stop. A perusal of Annexure Roman 2, which is enclosed to the writ petition, mentions is the work order as claimed by the petitioner. And from a perusal of the said work order, there is no mention whatsoever as to what is the consideration for which the work is to be carried out by the petitioner. It only mentions that about construction of a women's hostel under UGC grant within a period of 120 days, and the payment will be made on progress of the work. No document have been placed before this court which would substantiate that the petitioner, that there is, as regards the completion of the work by the petitioner. Considering the above, this court is not inclined to exercise its jurisdiction under Article 2 to 6 of the Constitution in the present facts and circumstances of the case. It is, however, observed accordingly the writ petition stands dismissed. Before parting with the record, this court, however, observes that in the dismissal of the instant writ petition shall not prejudice or preclude the petitioner to approach the concerned to a competent court of civil jurisdiction if so advised. To advise and permissible under law.
May I please, Your Lordship?
Service complete.
Service complete.
Service complete leads the matter for admission on 8th of June 2026.
Much obliged.
Why this MSc matter is before me?
Lordship, correction of the name and address of the claimant's respondents
Name?
in the judgment and order passed
Huh?
by your Lordship. Correction of the name and address of the claimant's respondents.
Of whose?
in the judgment order passed by your lordship.
Where?
Lordship, kindly see
Page?
page 9, lordship. Respondent number 3 is the son of the deceased. Is by mistake written as wife of the deceased. Respondent number 3, lordship, at page 9, lordship. 3 is the son of the deceased.
So the order is not wrong.
Order is not wrong, lordship, but problem is that unless and until it's corrected,
Understood. The order is not wrong. The mistake is yours.
not mine.
Absolutely.
At
We
least-
don't put, Mr. Counsel, you have to understand. In the judgment where it is there, these names are never put. Wife, son, or wife or daughter, it is not mentioned.
Lordship, can we see?
No, kindly see. You see the judgment. We're going to go ahead. See the judgment. We only put this. Your problem is when you file the appeal,
We have not filed. We
whoever
first
has filed it. So how does it affect you?
Lordship, the eroded amount has been deposited before the learned tribunal. And due to some mistakes in the name of respondent number 3 and address of the respondent number 1, 2, 3, 4 has been deleted, lordship, by the registry. That's the address, common address of respondent number 1, 2, 3, and 4 has been deleted, lordship. There was earlier there was an order.
But
Lordship,
order in the judgment, it is there, the address.
address is not there.
Okay. 1 minute. Okay, here there is no address.
Lordship.
But 1, 2, and 3 has been rightly mentioned in the memo of appeal.
In the memo of appeal, I'll kindly see, lordship.
They have not put the address. The address is not there.
Address-
But the memo of appeal, it has been rightly mentioned. But in the order, it has come up wrongly, na?
Lordship.
They should have mentioned 2 and 3. This is a mistake of the office.
Lordship.
Office. This is an application filed by the applicants who were the respondent numbers 1, 2, and 3,
1, 2, 3, and 4, lordship.
and 1, 2, 3, and 4 in MAC appeal number 236/2025. The grievance of the applicants herein is that though in the memo of appeal, the applicants number 2 and 3 herein,
Applicant number.
that in the memo of appeal, the respondent numbers 2 and 3, who are the applicants number 2 and 3 herein, have been shown as sons of late Mustafa Ali. But in the certified copy which was issued, the applicant number 3 oblique, the respondent number 3 in the appeal has been shown as the wife of late Mustafa Ali. This is a mistake committed by the registry at the time of inserting the name in the CIS. And as such, on accounts of such mistake committed by the registry, the respondents oblique the applicants herein cannot be permitted to suffer. Accordingly, this court directs the registry to correct the data in the CIS insofar as MAC appeal number 236/2025 in terms with the memo of appeal, and thereupon provide a certified copy of
Another mistake is there. Address is not there.
that I cannot. That I cannot put because here it is not there.
Lordship, can you see memo appeal?
See this.
Earlier order, Lordship. In ISC bill number 508/25, Lordship. Only respondent of 5 has been directed to be struck off. But the common,
এখন দেখাই দিচ্ছি। Where is the address?
address, common address, Lordship. 1, 2, 3, 4, and 5, common address. Address has been deleted, Lordship.
1, 2, 3, 4, and 5.
Common address. While striking of respondent 5, the address of all the respondents has been struck off.
কি লিখলে? CIS insofar as the respondent numbers in terms with the memo of appeal. And further, by taking into account the registry shall also insert in the CIS the address of the respondent numbers 1, 2, 3, and 4, which is also mentioned in the memo of appeal, and thereupon provide a certified copy of the order. I stand
Obliged.
Very pretty, Lordship. Due to my mistake, Your Honor, the repetition proceed, there is a error in the order, Your Honor.
What error?
Relating to the account number, Your Honor, last two number, Your Honor, 97 maybe 779, Lordship.
Huh?
In the account number, Lordship, in the last two number, Lordship, 97 maybe 79, Lordship. There is my mistake in the repetition, Lordship. That is why the error has been done. I may be allowed to correct in the repetition by hand, Lordship, and correct the order, Lordship. There is a typical mistake.
What is your account number?
Account number would be, Lordship, 8065279079, Lordship. And mine in the repetition, Lordship, I have typically written, Lordship, 97, Lordship. In paragraph, in page 11, Lordship, annexure 1, Lordship, there is account number, Lordship, serial number 1, Lordship. Last two number, Lordship, 79, Lordship.
Heard Mr. F. Hock, the learned counsel appearing on behalf of the petitioner. Mr. J. Hendrick appears for the respondent number 4. Have you seen Mr. M. Sharma today?
Put number 5.
Okay, he's there now. And Mr. M. Sharma, the learned counsel appearing on behalf of the respondent number 2 and 3. This is an application seeking correction of the order dated, judgment and order dated 11/3/2026 on account of a clerical and or typographical error in mentioning the account number of the petitioner. Inasmuch as the petitioner's account number maintained in the Indian Bank bracket Allahabad Bank is 80652790079, but have been wrongly mentioned in the order as 80652790097. Taking into account that there is a typographical or clerical error in the order, in the judgment and order dated 11/3/2026, the account number, the judgment and order dated the account number so mentioned in the judgment and order dated 11/3/2026 is corrected by observing that wherever in the judgment and order dated 11/3/2026 the account number has been mentioned as 80652790097, the same shall be read as account number 80665279079. The instant order shall be a part of the judgment and order dated 11/3/2026, passed in WPC number 645/2026. Highest tense allowed.
Apply.
And in this case, I have filed an miscase for impleadment of the opposite party number 3 as respondent number 3 in the original contempt proceeding.
Huh?
In the contempt petition.
You have filed for impleading.
Impleading.
Whom?
The respondent number, opposite party number 3, Commissioner and Secretary of the General Administrative Department, Government of Assam, Dispur, Gauhati. What had happened in this case,
You want the Commissioner and Secretary of the General Administrative Department to be a party?
Yes,
Okay.
but he is not the party in the original proceeding.
Why?
He was not there at that point of time because the allegation, basically we have claim against the respondent number 1 and 2. And what had happened, the respondent number 1 and 2 has taken a stand before this honorable court that the fund is supposed to be released to the petitioner has to be released by the opposite party number 3. And they have already communicated to them for releasing of the requisite fund. But after the several communications, the opposite party number 3 is sitting over the matter, despite the aware of the order of this honorable court. And in that circumstances, I have filed this impleadment petition for impleading the opposite party number 3, though he is not the party respondent in the original recourse.
Mr. R. Islam, the learned counsel appearing on behalf of the petitioner. Mr. Who appeared for the respondent?
One.
Mr. R. Dhar appears on behalf of the respondent number 1. You are appearing for respondent. So and so appears for the respondent number 2 and 3. Respondent number 2. This is an application to implead the Commissioner and Secretary to the Government of Assam General Administrative Department as a party to the accompanying contempt application. The reason for impleading the Commissioner and Secretary to the Government of Assam General Administration Department 8 that by the judgment and order dated 14/2/2025 passed in WPC number 5083/2024, there was a direction issued by the learned coordinate bench of this court that the bills of the petitioner amounting to that the claim of the petitioner amounting to rupees 6,91,494 should be verified, and thereupon payments be made by following the judgment of the full bench of this court in Tamser Ali versus State of Assam and others reported in 2008 4 GLT 1. During the course of as the order dated 14/2/2025 passed in WPC number 5083/2024 was not complied with, the accompanying contempt application was filed. During the process, during the hearing of the said contempt application, it came to light that the respondent numbers 1 and 2 have already taken effective steps for compliance to the order dated 16/14/2025 passed in WPC number 5083/2024. But on account of the Commissioner and Secretary Government of Assam GAD Department not taking steps for effective compliance to the order dated 14/2/2025 passed in WPC number 5083/2024. The respondent numbers 1 and 2 in the accompanying contempt application is not in a position to give effect to the order dated 14/2/2025. Taking into account the above, it is the opinion of this court that the impleadment of the opposite party number 3 of the instant application is necessary for due compliance to the order dated 14/2/2025 passed in WPC number 5083/2024. Accordingly, the opposite party number 3 in the instant application is impleaded as the respondent number 3 in the accompanying contempt application. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court and the registry within 7 days, and the registry shall, on the basis of the said memo of parties as well as the order passed in the instant application, make necessary corrections in the cause title and update the same in the CIS. IA stands disposed. Main petition. Contempt main application. Issue notice upon the newly impleaded respondent number 3 was returnable by 22nd of June 2026. Steps be taken by speed post within 3 days. This record.
Much.
This IA has been filed for correction of some addresses, Lordship.
What?
We have made some mistake in while drafting the writ petition, Lordship. The respondent page 11. Respondent number 5 was incorporated as the circle officer, Bullockganj Revenue Circle, but inadvertently we have written district Pokrajar, Lordship. It ought to be district Dhubri.
Respondent number
3, Lordship. 5, Lordship. And as your Lordship has given a direction to respondent number 5 to file the petitioner will file an application before respondent number 5 in paragraph 18, page 23. So
yes, who is appearing?
accordingly, Lordship, the address of the respondent number 3 is also required to be changed because we have already made district commissioner, district Pokrajar a party as respondent number 3. But now it is required to be made a district commissioner come district magistrate Dhubri. as respondent number 5 will fall under the jurisdiction of District Commissioner Dhubri.
Then the order will be wrong. The entire order has to be recalled. Because, Madam, the thing is that, you see, here it's okay, number 5 is okay. We
Yes,
can very well say Golagganj is District Commissioner of Dhubri, District Dhubri. This is okay, this can be corrected. But this, the other one is that you are changing the party,
yes, Lordship, is
and changing the party is not possible.
this is
We
because
reject your
only,
petition.
Lordship, the change of administrative jurisdiction.
I can't help it.
Lordship,
You,
then
it is your duty, because you see, that means I have heard the District Commissioner Dhubri, Koprajar, and passed an order, whereas it fell within the ambit of the District Commissioner Dhubri.
yes,
So therefore, the entire order is wrong. You have to
That-
file a review.
Lordship.
The learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to file a review application seeking review of the judgment and order dated so and so.
19/3/26.
Okay. 9/3/2026, passed in WPC number 5378/2025. And as such, the counsel appearing on behalf of the petitioner submits that the interlocutory application may be closed. Accordingly, the interlocutory application stands closed.
Now, please.
I stand.
Maybe the Lordship. Or we have filed an IA for implement of the new incumbent with joint as the Commissioner of GMC, madam. The earlier respondent number 1 has been transferred, madam. Without complying the order, he has been transferred, madam.
You want to impede whom now?
Not the Sinmoy Prakash Pokon, madam.
Tell me one thing. You have issued the advocate notice on 10/2/2026.
6 months is clear. Yes, sir. But it's a continuous process, madam.
Understood?
The earlier incumbent, without complying the order, has been transferred. So, madam, to bring,
No, you are initiating, we are to prima facie be satisfied
madam,
that this particular person concerned has committed the wrong. How? How will we come to a finding?
madam, it's the duty of the new incumbent to take over each and every file which has been done by his commissioner. So, madam, he is duty bound to comply the order, post order.
But he has been
We
given
have,
also
madam,
6 months.
in the writ petition, we make party to the CR, madam, not to the particular person, the commissioner.
Why you are not complying with it? Huh? You filed.
There are many cases pending by before this court, madam. But some of the petitioners have received their payment, madam. I have been replied. How they are maintaining, madam, I don't know.
Have you verified? How much is entitled?
They will be verified only if the amount will be less than 25% of the work has been completed. It is. What is it? It depends on the form.
Is an application to implead the present incumbent Commissioner of GMC as a party to the instant proceed, the accompanying contempt application. Inasmuch as the order dated 2024 passing WPC number 1571 of the 2024 have not yet been complied with. Considering that for effective compliance, the presence of the present commissioner, GMC, would be required, this court includes the opposite party number 2 as the respondent number 2 to the accompanying contempt application. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court, and the registry shall, on the basis of the present order as well as the memo of parties filed, shall make necessary correction to the cause title and update the same in the CIS. I stands closed. Main petition. Issue notice to the newly impleaded respondent number 2, returnable by 15th of June 2026. Mr. Esbora, who appears for the respondent number 1, submits that he would also be appearing for the newly impleaded respondent number 2. Pusto, extra copy of the instant application be served upon Mr. Esbora after making due correction to the cause title. Pusto. The respondent number 2, newly impleaded respondent number 2, shall file the affidavit in the brief. Same, na? Same order.
In this matter, Lordship, respondent number 2, the IG presents, has in the meantime been transferred to some other post, Lordship. Lordship,
You want to
so
implead who?
I pray for implement of respondent number 6, who has come in her place, Lordship, as IG presents.
Inspector General of Police.
Lordship. Presents, Lordship.
You have taken the possession of the vehicle.
Lordship.
Now what do you want? The payment.
Lordship, money payments.
আগৰ কোন নিচিনাকে এইটো বদলাই দিব GMC নকৰি এইটো Inspector General. You are paying for the new one? For the respondent number 6, are you paying? Notice. Issue notice making it returnable on main petition on 22nd of June. Steps be taken upon the newly impleaded respondent number 6 by speed post by tomorrow.
Lots of it. First one is the contempt.
Second one,
Second one is a replacement. That makes it.
What is the case?
Yes, my lord, it's a ceiling surplus land, my lord. Here what happened, my lord? The deputy commissioner has fixed the case, my lord. Land for ceiling surplus. Uh, Your lordships will find, my lord. The order, my lord, you see that starts at page 27, my lord. Your lordships may just see para 10 at page 31.
This acquisition is made under what provision?
Ceiling act, my lord. Ceiling act.
The land has been, the 7-5 statement has been made.
Yes, my lord. Here they have taken over, my lord, 2552 bigha land from us and 139 bigha they have paid, paid more. My lord. If you also see para 10, page 31, my lord.
Well,
Then-
what are you challenging?
My lord, here what I am challenging, my lord, is subsequent again execution. My lord, we prepared a revision before the government. Government, after calling for the report, my lord, he passed an order at page 45, my lord. They said that we can be allowed to retain 1200 bigha more, my lord.
Okay, then,
Then, my lord, whatever this revision was disposed of.
Huh?
Again, my lord, subsequently a government passed an order dismissing the same, my lord.
Where?
Page 68, my lord. Without hearing us, my lord. Because after disposal, my lord, how that can be done?
which order?
Page 68, my lord.
Page?
68.
This was passed when?
This was passed, my lord, ni- yeah, 17th November, my lord. My lord, I'm just next page. Originally there. 17 November 86.
Huh?
17 November
80?
86, my lord. Yes.
So you have challenged this order?
Yes. No, not this was challenged, my lord. Before this no court earlier.
Ah.
Then, my lord, this no court remanded the matter to government, my lord, to dispose the matter. Page 70, my lord, this is the order. Then this matter was page 73, the matter was remanded back. Then, my lord, the government has not disposed of the matter. And in the meantime, my lord, the deputy commissioner again, my lord, is made some assessment on the basis of which, my lord, we have
Where?
come before you, my lord.
Where?
Well, yes. Well, page 90. There is some confusion that they have already acquired 2 bighas of land. We have filed objection. Then, my lord, they have filed a petition to give the copy of the reports, but without considering that, my lord, they have passed an order upholding the earlier order, page 102.
Thereafter,
But against this, my lord, page 103, my lord, against this order we have come. We have asked for some 103. Except 20. We asked for some documents without service. Giving the documents, my lord, they have disposed of the fact.
where is the final statement?
They have not given us, my lord. But they have.
Yes, yes.
We have asked for that, my lord.
Mr. Arbor-Pujari, where is the final statement?
We have asked for that. They filed it.
Take on the phone, some lengthy.
Final with regard to initiation of civil proceedings. It would say regarding the earlier proceeding where they have taken over, 3552 accord, my lord, and 138.
See, unless you publish the final statement, there's no business.
Yes, I did deal with that or Gauhati matter. That is a difficult thing.
Because with this final statement being over, at any time after the land are transferred to even subsection 4 is proceed to take possession. Anything contained in the next subsection with effect from the date on which the final statement is signed by the under the proceeding therein, all rights of the so and so shall stand transferred to and vest in the state government free from all encumbrance. Shall be prepared under subsection 3 above and shall be published in the manner 15 days of the year shall be considered equal. The draft statement shall be published in the office of the union and copy thereof shall be served to law. So without the final statement, what is the business?
The final statement is the culmination here, it could be a sitting case.
Chilling case is there. No, what has happened is this. Chilling case was started in 1979. After this, it was started, there were certain proceedings being initiated. And the final statement thereupon was passed.
Yes.
Thereupon, they filed a revision before the government. The government said that additionally they can retain 1200 bighas.
Yes.
84. Then all of a sudden, 1986, on their own, the government revised it and said, no, 2900 bighas can be taken away. For that, they filed a writ petition. Writ petition said, order says that they were not given a hearing, they could not have taken by that. And therefore, there was a direction to do it. Now, the question is, how is the collector exercising it?
Once it has gone to the revisional authority,
So the revisional authority has to do it. So this entire action is going to.
Predicament is there, because my affidavit is.
And Mr. Bopudari, I've seen this government, what is wrong with this government? The government mentioned many documents in the affidavit, but why they don't enclose? Is the government advocate saving money for the government? Huh? The photocopying expense. Now, this is not the first. Yesterday I had to say, day before yesterday I said, you are mentioning about various documents in this document, in this affidavit. And when you mention an affidavit, certain documents out there, if you don't enclose those documents, how this affidavit cannot supply it. We have to follow the same principles as per section 91 of the Evidence Act. Now it will be 89 if I am not wrong of the BSA. But this is the principle.
Well, already they have taken over 3552 bighas of land in the first proceeding. They say only 138 bighas remain. That is why we filed a revision. Revision at that stage. They have already taken over 3552. Total land declared 138 become more. So again, which we have to filed a revision.
No. My question is this, Mr. Sahiwala.
Yes.
Certain, in 1979 or 77, certain sealing proceedings were initiated. Certain lands were being taken, said that it was sealing surplus.
Yes.
Then it led to a final statement.
Yes.
This final statement was challenged by filing a revision.
But
Well,
prior to that, my lord, they have taken over 3552 bighas.
Understood, whatever may be. Out of that,
Yes.
you have been allowed to retain 1200 of the 3552. Isn't it?
Yes.
1200, then you were satisfied and be happy. All of a sudden, they ex parte
Yes.
passed the decision in the year 1986. Now that 86 decision you challenged in a writ petition.
Well.
The writ petition order,
Yes.
the writ petition passed in the writ petition, that order of 22 May 1986 was set aside.
Yes.
And thereupon, there was a direction to, if you want, you can further decide to look into it.
Yes.
It is to be then decided only by the revisional authority.
Not bad.
But why is the collector exercising the power?
Well, that is why I am.
But why you are on 138? You should say therefore
Yes,
that that order of 2084 should remain.
Yes.
Then, if I'm not wrong, I'm giving the petitioner more here than what he is asking. That's something must be wrong.
I may be allowed to produce the reports, my lord.
You have a look at the records, because what I see, you kindly see this order.
90.
No, kindly see this order. Kindly come to page 68. 68, the deputy commissioner, this is an order passed by whom? Copy of the order of the governor. Means this is an order passed by the government.
Yeah.
In the year 17th of November 1986. Now this order was put to challenge in the Civil Rule 1343 of 1986. Now this order was set aside. It allowed the order dated 19/9/1986 contained is set aside. We direct the state government in the revenue department for fresh hearing on the revision petition and dispose of the same on merit in accordance with law. Kindly see page 73.
So, my lord, page 68. My lord, speaking of page 68. Can you see whether the revision petition appears to have been disposed of by the additional deputy commissioner?
No. On top you see copy of the order of the governor.
The orders of the governor and the deputy secretary to the governor were forwarded to the deputy commissioner.
And therefore he has forwarded it. This is, you kindly see copy forwarded to so and so, and this is by the additional deputy commissioner Kacha. In fact, it should not have been done like this. But anyways, this order has been set aside.
But that order of 19/9/1886. That is to be seen by law.
Anyway, so kindly see 19/9/86. This has been forwarded by 17/11/1986. Okay, now kindly come to this repetition, page 70. This is a challenge to the 1986. Kindly see page 72.
Yes.
1986. And then you kindly see page 73,
Yes, page 73.
paragraph 7.
Yes.
The order so and so is set aside. We direct the state government in the revenue department for fresh hearing on the revision petition. Means the revision petition which is being filed. And dispose of the same on merit in accordance within a period of 4 months. Now thereafter, if you see case record, deputy commissioner, so and all this goes on, and then I'm directed to say furnish comments on the deputy secretary. This is being done by the additional deputy secretary in writing reference, so settlement officer. I am in receipt of your letter, the reference dated so and so. Pending before the government in revision, and the copy of the Iman is given and so and directed so and so. We can petition by to the deputy commissioner. Now the deputy commissioner takes it. Now my question is, how did page 90 come into being?
Prior to 90, at least in my lord, in the repetition annexer 5. We say my lord, annexer 5. Annexer 5, you kindly say my lord. Paragraph 10 at page 9.
Huh?
Paragraph 10 and paragraph 10, page 9 of the repetition. Kindly see.
Yes.
Petitioner stated the state of Assam of its own examining the matter without giving. So
No, that is okay. No, it's okay. No, I understand, Mr. Yeah. My question is, no, okay, I'm not on that. My question is 1986 was set aside by the division bench and directed the revenue department to decide.
Yes.
FS. Now, why page 90 come into being? Unless there is some order somewhere by the revenue department for initiation of this. Because what do they refer? Kindly see. Seen the copy report of the so and so 2015 along with the LR staff dated so and have submitted the draft final statement for Iman of the land of Iman along with the government order dated 22/5. 22/5 allows them to maintain another 1200 bighas. Honorable High Court's order dated 9/11, that is the challenge to the 1986. And the order of the government passed in response to the government's letter dated 19/9 alia, whereby rejecting the petition. Now, where is this order?
That order is not annexed and in the.
No, and this order, there is no mention of the date. Only see, this is the reason. And the order of the government passed in response to the government's letter. Where is this order?
And why not the order dated 19/9/1886 is also not annexed to the petition. Therefore,
There is no mention of the date also, no? Problem like that.
Page 69, my lord, the original copy is there.
Huh?
Page 69, original copy is there.
Page 90, which Lordship has just now seen, is a follow of my lord, page 68. Page 68, kindly see, my lord, page 68. Actually, in the writ petition, in the index part, my lord, in the writ petition, annexer 5 has been stated to be ordered at 19/9/1886 in the writ petition. Now, if we come to annexer 5, we see, my lord, annexer 5 at page 68. Now, page 68 is not an order passed by the government.
No, that I understand. That is different. You find out this, page 90. They refer to everything. And the order, now kindly remember at page 73, the learned division bench says that this order of 19/9/86 is set aside and understood and directed the revenue to take the decision by hearing the parties. Now, kindly see, therefore, you see the connection. Now, kindly come to page 90. The order dated 9/11/97 passed in so and so, meaning thereby directing the revenue authority to decide. And the order of the government passed in response to the letter where rejecting the petition of the Iman and vacated the stay. Now, which is this order? Because you have to, the connection is here. There's no mention. Considering the draft statement is being hereby, again, like now what they do. Considering the above, the draft statement for acquisition of so and so is hereby published today for verification and filing objection again. Meaning filing objection. Then what has happened is they say,
We ask for copies.
huh?
We ask for copies, page 91.
Now whatever may be, now kindly come to 103. 103, the deputy commissioner passes an order, which is the subject matter of challenge. Here again it says that as the guardian authority concerned, and there is no reply, proper reply who has been submitted and has been acquired. So this is being acquired. So this is an order which is being passed after hearing. Now, where is that order? The missing link. That missing link order has to be there somewhere. And that is not there. Not a part, because you also not mentioned what is that order.
My lord, in fact, my lord, what we mean, my lord, that in the
Huh?
in the Annexure 5, my lord.
Huh.
The Annexure 5 in the next, my lord, it is stated, my lord, that it is copy of order dated 99. That is why, my lord, that is the mistake, my lord.
No, that is, we are not concerned. 9996 is gone, 86 is gone. My question is, after the division bench order, what is the order passed by the revenue department?
No order been passed.
So therefore, without that order being passed, how does this person gets any jurisdiction?
That
Is the issue is this. And if it is passed, because there is no mention here, na. Kindly see, therefore I'm saying page 90. And the order of the government passed in response to the government's letter dated so and so. Where rejecting the petition. Now, if the deputy commissioner is relying on an order dated 19/9/86, then obviously this proceeding has to again go because of the fact that that order has already been set aside. So let me now frame up and give it to them and ask them to find out. I'm aware. Heard Mr. G.N. Sahewala, the learned senior counsel, assisted by Mr. H.K. Sharma, Mr. R. Putari appears on behalf of the Revenue Department. Mr. J. Hendik appears for the Deputy Commissioner for the District Administration as well as the Settlement Officer. The petitioners herein have assailed the order dated 29/6/2018, passed by the learned Deputy Commissioner Kachar Silchar in land sealing branch. The brief facts which led to the filing of the instant writ petition are that a proceedings under the Assam Land Fixation of Sealing Act, Fixation of Sealing on Land Holdings Act 1986 was initiated, which was registered and numbered as land sealing case number 1/75-76. The final order was passed on 13/7/1979 under section 7(6) of the Act of 1956, whereby
Page 27 the detail order.
No, whereby, in the final order not, whereby an order was passed on 4/7/1983. By the Office of the Deputy Commissioner Kachar, thereby coming to a finding that 3690 bighas 4 kathas 0 chatak was the total surplus land, and out of the same 2552 bighas 2 katha 1 chatak was acquired by the collector, and there was a balance area of ceiling surplus liable for acquisition comes to 138 bighas 1 katha 0 chataks. A revision was filed under section 7(6) of the Act of 1956 by the government, by the petitioner before the Revenue Department of the Government of Assam. And an order was passed on 22nd of May 1984, holding inter alia that the petitioner estate should be allowed to retain 1200 bighas of land at Kaspur Gran in addition to the area already allowed by the collector. And this would reduce, with an opining that the same would reduce the surplus determined by the collector. Pursuant thereto, who has issued this document at page 43? Pursuant thereto, the Office of the Deputy Commissioner Kachar have written a letter to the Special Secretary to the Government of Assam, Revenue Reforms Department, in the month of September 1985. The records further reveal that on 1986, some order was passed by the governor of Assam through the Deputy Secretary to the Government of Assam, whereby The revision petition filed by the petitioner under section 7(6) of the Act of 1956 was rejected. The petitioner thereupon challenged the said order dated 1986 before this court by filing a writ petition which was registered and numbered as Civil Rule number 1343/1986. And the learned division bench of this court, by the judgment and order dated 9/4/1997, isn't it?
Yes.
97 or 91? Huh? Very difficult. 91, huh? 9/4/1991. Set aside the order dated 19/9/1986 on the ground that the said order was passed in violation to the principles of natural justice. The learned division bench of this court further directed the state government in the revenue department for fresh hearing of the revision petition and dispose of the same on merits in accordance with the law within a period of 4 months after duly serving notice on the parties. The records further revealed that there were certain correspondences by the revenue department with the petitioner in respect to the land ceiling case number 1/75-76. But from the materials on record, it does not show as to whether there was any hearing granted to the petitioner and any order passed by the revenue department as directed by the learned division bench of this court in WPC in Civil Rule number 1343/1986. Be that as it may, it is seen that a notification was issued on 3/2/2018 by the Deputy Commissioner Kachar which apparently was a notification of the draft statement in terms with section 7(2) of the Act of 1956, calling for objections. The question, however, arises is as to whether the revenue department of the government of Assam have passed any order in pursuance to the directions passed by this court dated 9/4/1991 in Civil Rule number so and so. Inasmuch as, in absence of such order, the Deputy Commissioner Kachar would not have the jurisdiction to issue this draft notification dated 5th of February 2018. 3rd of February 2018, which is at Annexure Roman 17 of the writ petition. It is further observed that in the circumstance that notification dated 3/2/2018 cannot be issued by the Deputy Commissioner, the impugned order which was passed on 29/6/2018 cannot withstand the scrutiny of law. An affidavit has been filed by the respondent number 2, and there is no clarity on the said aspect. Mr. Arbo Pujari, the learned counsel who appears on behalf of the Revenue Department, submits that he would like to peruse the records and file an additional affidavit if so required. List this matter again on 8th of June 2026. In the meantime, the additional affidavit be filed on or before 3rd of June 2026. The records pertaining to LC case number LC case number 1/75-76 also be produced on the next day. There is some interim order.
Stay,
The interim orders, if any, stands extended till the next day. Yes. Mr. Goswami, what is this? That I know. I know you have not changed your loyalty from the railway to the become a petitioner. What is this case? You file affidavit. None appears on behalf of the petitioner on call. Mr. G. Goswami appears on behalf of the respondent, Railway Department. For ends of justice, this court is not. For ends of justice, this court adjourns the matter with an observation that in the circumstance the petitioner is not represented on the next date, this court shall pass appropriate directions. List this matter again on 18th of May 2026.
My lord, this is relating to the contract matter, my lord. In this case, the contract was awarded for the construction of internal road, mainly for earthwork, my lord. And after awardment of the contract, my lord, there was a ban imposed by the Deputy Commissioner at page 43, my lord, for excavation of the earth, my lord.
Then,
my lord, and there is a provision, my lord, in the Assam Minor Mineral Concession Rules for taking permission from the Forest Department. And I have quoted the relevant portion, my lord, at page 19, my lord.
Then,
So because of non-granting this permission by the Forest Department and ban imposed by the Deputy Commissioner, my lord, the contract was frustrated and could not be started. Because in absence of the necessary permission, it is not possible to do the work. And because this is a punishable offense also, they can seize also the. Then my lord, the contract expired. After granting the extension, the contract expired. And thereafter I sought extension, but no extension was granted and it was terminated. So my lord, they forfeited my performance guarantee. And as such, I have come before your lordship.
why should we exercise 226?
My lord,
Why?
because
There's nothing. Go there. You have an arbitration clause.
yes,
Railway.
yes,
62.
CPWD,
CPWD arbitration clause is there.
clause there.
Go there. Go there. We exclude this period from here. These are questions which is absolutely within the domain of the contract. You go there, you have where's the arbitration clause? Arbitration or civil court, all these things, huh? Where's the agreement?
General conditions of contract of the CPWD.
Huh?
In general conditions of contract CPWD, the arbitration clause is there.
Yeah, so go there. This take care of this thing, the limitation.
Yes, my lord, the period may be excluded.
Heard Mr. R. Hussain, the learned counsel appearing on behalf of the petitioner. Ms. S. Borua appears on behalf of the CPWD. R. Gogoi appears for the Forest Department. So and so appears for the district administration. And Namgita Didi Punya Putti Kia Konshi. We have only 3 petitioners. Why you have been impleaded. Okay, Ms. So and so appears for the respondent numbers 1, 2, 3, 4. Ms. S.R. Boro appears for respondent number 5 and 6. Mr. R.R. Bogo appears for respondent number 7. The present petition has been filed by the petitioner seeking a direction of seeking the following reliefs as mentioned. The following reliefs, which are reproduced herein below. A 1, 2, 3, 4. It is the case of the petitioner that the petitioner was awarded a contract for construction of internal roads at 33rd BN ITBP or SIA, Punapur, Gauhati. However, on account of not granting of the permissions by the Forest Department of the government of Assam, as well as the ban imposed by the district administration, Kamrup, the petitioner could not complete the work, and resultantly, after issuance of show cause notice, the petitioner's contract was terminated and the bank guarantee invoked. The petitioner, therefore, has approached this court by filing the present petition. The issue involved in the instant proceedings. Now, it is the opinion of this court that the issue involved in the instant proceedings relates to as to whether there was any breach of contract by the petitioner or the petitioner was restricted by conditions beyond its control to perform the terms of the contract. So these aspects cannot be decided by in a writ proceedings, taking into account that evidence in that regard has to be led as to the existence of such circumstances which restricted the petitioner or which did not permit the petitioner to carry out the performance of the work. This court, during the course of the hearing, inquired with Mr. R. Hussain, the learned counsel appearing on behalf of the petitioner, as to whether there is any arbitration clause taking into account that such disputed questions of facts has to be dealt with in a forum wherein facts can be, evidence can be led. Mr. R. Hussain, the learned counsel, referred to clause
25
of
GCC, general conditions
the general conditions of the contract of
CPWD,
the CPWD.
central,
There's nothing named.
nothing. 2014,
CPWD 2000. General conditions of the contract 2014 of the CPWD, which permits that such disputes to be decided by way of arbitration. Clause 25 of the said of the general conditions of the contract being relevant is reproduced herein under.
yes, I will.
Taking into account the above, this court is taking into account that the present dispute not only relates to would require detailed factual examination on the basis of evidence led, and further that the dispute is arbitrable in nature. This court is not inclined to exercise
the jurisdiction under Article 2 to 6 of the Constitution. This court also duly takes note of that the petitioner had bona fidely and diligently been pursuing the present proceedings. And under such circumstances, as this court is not entertaining the dispute on account of disputed questions of facts, as well as the dispute being arbitrable in nature, the period during which the instant writ petition has been pending is required to be excluded in terms with Section 14 of the Limitation Act 1963. Accordingly, the instant writ petition stands disposed of with the following observations and directions. Number one, this court is not inclined to exercise the jurisdiction entertain the instant writ petition under Article 2 to 6 of the Constitution on the ground that the dispute involved in the instant proceedings would require detailed examination of factual disputes. In addition to that, this court also is not exercising the jurisdiction under Article 2 to 6 of the Constitution on account of, is not inclined to entertain on the ground of existence of an arbitration clause. Number two, the petitioner would be at liberty to the repetition accordingly. Number two, the repetition accordingly stands dismissed. Number three, the dismissal of the instant writ petition shall not preclude or prejudice the petitioner to initiate appropriate proceedings under the Arbitration and Conciliation Act 1996 in terms with the arbitration clause as quoted herein above. Number four, the period during which the instant writ petition has been pending, that is, with effect from 26/4/2021 till date, be excluded while computing the period of limitation. But you have to like
Made, please, Lordship. Made, please, Lordship.
yes.
Made, please. Lordship, here, the petitioners are the employee of this.
Yes, what is the case?
Lordship, this petitioner is serving as a driver at Chief Judicial Magistrate at the Court of Chief Judicial Magistrate, UPR. And petitioner number 2 is a process server at Judicial Magistrate First Class at Changlang. And both of them are husband and wife, and they are seeking for joint posting at UPR, Lordship. For that, Lordship, may I take to
Petitioner is
annexer
working as what? Both the petitioners?
driver, Lordship.
Both the petitioners are
Petitioner-
working?
Lordship, petitioner number 1 is driver
And petitioner number 2,
as a process server.
and they are
But she
working
said-
where?
Petitioner number 1 is at UPR, Papumpari district. And petitioner number 2 is at Changlang. At the at Changlang district. Petitioner number 2 working as process server at Changlang district.
And the other is that posted at
Changlang.
Sepa.
No, Lordship, from SEPA, he got transferred to UPR now.
Have you submitted a representation?
Yes, Lordship, that my representation is at Annexer 6, page 23, Lordship. Page 24, Lordship. Page 24, Annexer 6. Lordship, my limited prayer is that this representation may be disposed of.
Where is your representation? 1/11/2025,
Lordship, yes.
page
1/11,
24.
2000, page 24, Lordship.
Who is appearing for Guwahati High Court?
My lord, I'm appearing.
We issue notice out here and ask the Guwahati High Court to consider the representation, keeping them apart to what good sense prevails upon you.
Yes, my lord.
After all, they are husband and wife. And that too, they are all in grade 4, na?
Lordship.
Yes.
These are grade
They
4
also-
posts. Process server and driver.
Lordship.
Also, they have a small child recently.
Who appears for the Guwahati High Court in the principal seat? Huh? Have you seen him around? I've also seen him somewhere. Kindly call him. We take your matter after some time, okay? Wait for some time. Let him come. Because your process, this representation can be disposed of out here in the principal seat. So let the principal seat raise the the lawyer come out here. We'll take it up out here. Okay?
Obliged.
Wait for some time. Mr. Bhattacharjee, your matter.
Lordship, I beg to refer the page 248 of the IA, official notification, permitting superintendent to invite tender up to 1 crore. Above 1 crore, he is not permitted. And these letters you see, Lordship, both the letters same date, same language, same handwriting, same pattern.
How many bidders were there?
One bidder.
2 bidders.
I have filed the RTI asking the CS copy, both the tenders.
And how much did the other person put? How much did the other person put? No, because I see the financial bid having been opened, this person concerned quoted the amount which was mentioned in the NIT. Okay, means the other person must have quoted lower. Huh? Why they don't mention about, I have seen many papers of tender documents where is always the mention of the 2 bidders.
I filed the RTI seeking that CS copy, property statement from the Sugar office. Then picture will be clear.
And how much You do one thing, produce the records of these two. How many contracts are there?
Two contracts of 6.40 crores, and both the were given to the same bidder. And this is the letters permission, same letter allowing them, same handwriting, same date.
Okay, register contractor to the election department in the cycling for period of time.
Is
There
there
is no locus of
locus 3 years gone now? You are questioning the locus.
the beginning of there is no locus.
Both the letters, same date, same handwriting, same pattern of writing. But the both are different office. Both are different office.
But this is a different work. This
Different
is the
work.
same work.
Different work.
Different work.
Different work given by both different authority, but language of the letter is same, date is same, and this permission cannot be given because he is empowered up to 1 crore. Why the purpose and motive of giving more than 1 crore to Gauhati office when it can be invited from Gauhati office?
Lawsuit, the tender was quoted in the year 3 years. And he was not a registered contractor for 2 years. My friend. And that was a condition in the.
No, this is, that is, I was registered or not renewed, that is not the issue. Issue was whether the criminal motive is there on that is. Pre-bid criminal conspiracy is there to award the contract to single bidder. Up to 6.40 crores, not a small amount. And the money is also 25 lakhs, the irrigation department.
I tried the liberty to file an FIR PI. This case.
These are different orders passed by the school.
No, you have given these two copies. Both copies are same.
Both copies the same date.
No,
One
this is in respect to the same contract, what document you are giving of 7/6/2023.
IA 187 and 18888.
188, these are two are same page.
No, no,
18.
Elias Coffee Park.
Please see 187 please.
No, Mr. Bhattacharjee, both are 188 page. It's the same copy you are giving.
If he deferred a petition. The rejected, he deferred then a appeal.
This is different case, this is different case. Now appeared, judgment is there. Judgment is on my mobile, judgment is there. No, this is not like it. Let's say page C187 of the IA. Let's see page 187 of the IA, please.
Where is in the procurement act, it cannot be more than 1 crore.
This is page 248 of the IA.
As per the procurement act,
Procurement is not applicable here. That delegation is applicable. Please see, kindly see 240 of the IA, 248 of the IA. Is it is 248 of the IA. SC is competent up to 1 crore.
in pursuance to section Imani of the Iman, the governor of Assam is pleased to direct the following further amendments to so and so. Who is paying for the finance department? Yes, tell me. Can the chief engineer or the additional chief engineer delegate the authority to call for a tender beyond to the superintending engineer? No, kindly come to show this document to him.
It's sorry. This is
Kindly see this notification. This is the finance department notification.
any authority vested with.
They are in the Disqualification. That part, my lord, I have seen 5-7. Rule 5-6, sub rule 7.
Oh,
For this, my lord,
no, I'm saying about this notification. The notification issued by the government. 208 for 248. Mr. Bhattacharya,
248.
date of the notification.
19th of December 2016. Yes. Here the issue of technical sanction to original work and special repairs, exclusive departmental charge, CE full power, additional chief engineer 2 lakh, 2 crores, superintendent engineer 100 lakhs, executive engineer 10 lakhs. Acceptance of the tender.
Yes, next, please.
This is full power. Then additional chief engineer 100 lakhs
Yes.
and to 200 superintendent engineer 10 lakhs.
What?
Okay, this is for acceptance. Now, in these cases, the acceptance has been made by the chief engineer.
That is what the information that has been furnished by
No, the acceptance has been made by the chief engineer, as it would be seen.
But redelegation is not allowed.
Huh?
Redelegation not allowed. Redelegation by the chief engineer is not permitted. As per.
No, I'm not on that. Rate quoted by the lowest bidder is accepted. The works may be allotted to him. This is done by the chief engineer.
Chief engineer, which date or two?
15/7/2023.
How is it possible? 14/7 tender was opened in Jorhat. 14/7.
Now, this is for the, this, MDTW 5 points at Rangamati, Moza.
Yes. This tender was open was 14/7/2023. And technical was open 14/7, 15/7 LOA is issued 15/7. Immediately within 24 hours.
Where is the tender document?
Yes. Yes. NIT, IA, copy to NIT 15, page 80 and 91, page 80 and 90.
Now, this is the work, page 27 of your IA.
No, copy of the NIT dated.
Mr. Bhattacharya, page 27 of your IA is the work.
I got to Lordship. Kindly see page.
This is for 1 crore Iman.
Page 25, Lordship. Kindly.
No. Technical bid opening 14/7.
Yes.
So 14/7, then 15/7, they have allotted it.
But
what is the problem?
Problem, office of the additional Gauhati, chief in office of the additional chief in Gauhati, and SE office in Jorhat. That technical evaluation, financial evaluation, minimum takes time, some committee to be formed. So within 24 hours or office hours, 10 hours.
So go and file a criminal complaint. This court is not going to look into it because of the fact that on 14/7, the technical bid opening is there. The financial bid will be open subsequently. On 14/7, they may have opened it, and on 15/7, the chief engineer, upon opening of the commercial thing, they have looked into it.
But within 24 hours from Jorhat to Gauhati, they came and again gone back and issued the LOA. Is it some minimum time is there? What is so urgency? What is the so urgency to allowing the single work to a single bidder? That is the issue. And other work 4.91 lakh, that is one bidder.
SSK Industries and MP Agarwal. Whereas so-and-so is qualified for financial bid. Accordingly, the financial bid is open. So this is single tender. Huh? Now, there is a clause as per 35 of the procurement. Whether the Procurement Act will not follow. What do you say about this clause 2320 of the procurement rules? And this can be done only by way of taking the permission from the finance department?
Yes.
Huh? Isn't it?
The rules which so
Now here it says 2320, where a situation arises where after evaluation of the bid evaluation ends up only with one responsive bid only. The committee shall check as to whether while floating the notice inviting tender, all necessary requirements to encourage the competition so and so was done. If not, the committee shall recommend cancellation. Then, subject to strict adherence to all prescribed procedure and other relevant rules in these rules and the provisions of the Act which shall be certified in writing by the concerned procurement authority detailing the process undertaking, the bid process shall be considered valid even if there is only one demand provided. A, the bid is technically qualified, the price quoted is assessed to be reasonable, the price is unconditional, so and so. In such cases, the bid evaluation committee shall prepare a justification note in which the specific views of the finance and accounts officials members shall be necessary and on which the approval of the next higher authority of the procuring entity in terms with the relevant delegation of powers shall be obtained. The bid shall be finalized only after approval from in consultation with the finance and accounts officials members.
The finance and accounts officer, there is a FAO madam. That FAO is there in every department. Not the finance department as such.
But all exercise is done in one day.
As per the clause. So there are two contracts. One is of 148 or something, the other is 491.
491 single bidder, no second bidder. 491 single bidder participated at per date, and he was allotted to work.
Single bidder is permissible.
Permissible, but there's the peak. Let me submit it. Condition of the tender was that bidders before participating in the bid is to inspect the site, and site inspection report to be annexed with the tender as a proof of evidence, as a proof. Then, as he told the executive engineer not to show the site to any other bidders except the MP Agarwal, private 7. As a result, he quoted at per date. But tender was there. Bidders quoting less than 5% rejected. So he quoted at per date because there was no competitor. He got the 4.9 was that. There is a monetary loss of rupees 25 lakh per department.
So did you participate?
No. My question of participant did not come because condition was, you see the order as passed by the Sumansiam that I've given just. Initially, first tender 1.4 crores, tender clause was 80% cadence, in place of 30%. Tender clause supposed to be 30%. Order passed by the Honorable Mr. Manish Bhai. Order tender clause should be 30%. Cadence, yes. To award the contract to him, it was risen up to 80%. As a result, out of 1 crore 40 lakhs, 80%, 1 crore 20 lakhs, no small bidder could participate because 30% then different thing. So I didn't participate. When it was rose to 80%, MP got a submit tender. He got award 1 crore 47 lakhs. And within 1 month, another tender was accepted. That is 4.91 lakhs. He again came down from 80% to 30%. Within 1 month. That is the case. Both the NIT clause is different. But he did not submit the counter petition for 641 because he knew that he'll be in trouble. 2 tenders, gap of 1 month. First tender, 80% cadential.
80%?
Cadential, 1 tender. But out of tender value. Other tender within 1 month, one is 15.6, other 15.7. Again, came down to 30%. Because 80% capital not having an MPI. 80% cadential after 5 crores is not available with MPI. So it came down to 30%. So unless and until we go through each and every points of the 3 writ petitions as well as the IA, we cannot arrive at conclusive findings. That's the problem.
But why should we look into it?
No. I don't say that it is purely pedagogical, honorable, but my problem is, my submission is that this court issued a notice to file their objections. They didn't file a notice.
Who?
The department, as well as the private respondent 7, who was directed by this court order dated 22/4 to file their objection why his payment will not be stopped. Giving 4 weeks time. 2 years gone, no? The order is with you, just like me. He was out of the court telling me the to withdraw the case. If I'm honest, Lordship, I was told by many times, I should not want to scale diverse thing as yet. To withdraw the case, why withdraw the case? They are saying to withdraw the case. Why withdraw the case? If I defeat the case, if I'm defeated by this case, there is no merit, that is different thing. But how can I, why should I withdraw the case when I know there's some foul play going on, pre-bid conspiracy, criminal conspiracy, in furtherance of common intention to award the contract to a single bidder.
So then why you are not filing a criminal case?
That is, matter is, Lordship, for this court pass an order giving me liberty to pass an.
There is no liberty required. You already have the liberty.
On record is good for me. If on record, it will be helpful for me.
Mr. Bhattacharya, if this court gives you some indulgence, don't take it so much that this court is going to pass on in directions. Heard Mr. P. K. Bhattacharya, the learned petitioner in person. Mr. P. Gogoi, the learned additional advocate general, as well as the standing counsel of the finance department. Mr. N. Upadhyay, the learned standing counsel of the irrigation department, and Mr. D. Gogoi, the learned counsel appearing on behalf of the respondent number, on behalf of the private respondent. The 3 petitions are taken up together for disposal by the common order. First, WPC number 4185/2023 has been filed by the petitioner challenging seeking a direction upon the respondent number 5 bracket the superintending engineer irrigation Jorhat circle to stop the tender work including allotment work and further sought for in the interim to stop the entire process including allotment if made till the disposal of the writ petition. The material facts on the basis of which the present writ petition has been filed is that the respondent number 5, that is the superintending engineer Jorhat irrigation, had invited an online bid by the notice inviting tender dated 15/6/2023 for an work inverted comma MDTWS bracket 5 points bracket close at Rongamati Moja under RIDF Roman 28 NABARD for the year 2022-23 amounting to rupees 1,48,50,098 bracket approx under Bukakhat Kumtai Division Irrigation Bukakhat. The last date for submission of the bid was on 13/7/2023 at 2 p.m. The notice inviting tender included various terms and conditions as is mentioned in the various sections of the said notice inviting tender. The instruction to the bidders, which is section 1 to the said notice inviting tender, stipulated the eligibility of the bidders, the qualification of the bidders, and what the bidder should demonstrate for to qualify for the contract. It is the case of the petitioner in the instant writ petition that the respondent number 5, that is the superintending engineer Jorhat, had hurriedly allotted the work to the respondent number, to the private respondent, that is the respondent number 7. He was made a party subsequently. To the private respondent have allotted the work to the single bidder who participated in the said bid amounting to rupees 1,48,50,098. The grievance of the petitioner herein is that when the petitioner was asked, when the bid was only submitted by a single tenderer, single participation. The bid could not have been, the authorities concerned ought to have cancelled the said notice in said tender process and should have refloated the tender. It is under such circumstances the said petition was filed. It is pertinent to take note of that the said petition was filed on 24/7/2023. And this court, by an order dated 4/8/2023, issued notice but did not pass any interim directions. The petitioner in person, next. The petitioner in person filed the second writ petition being WPC number 6431 of the 2023. Seeking a direction upon the respondent authority to suspend the work order issued by the superintending engineer Jorhat Irrigation Circle with immediate effect, and to recall and or otherwise forbear for giving effect to the formal work order issued by the superintending engineer Jorhat dated 14/8/2023. The petitioner have also sought for issuance of directions as to why criminal proceedings should not be initiated against the superintending engineer Jorhat Irrigation Circle, as well as the private respondent number 7 under the specific provisions of the Indian Penal Code for criminal conspiracy in furtherance of their common intention. A perusal of the said petition would show that the petitioner herein have referred to two tenders. One was the tender, which is the subject matter of WPC number 4185/2023. And the second tender is another tender issued on 15/7/2023 for the work inverted comma LIS from River Doyang at Greater Gomari area under RIDF-Roman 28 bracket NABARD for the year 2022-23 amounting to rupees 491,39,319.00 approx bracket under Gulaghat Korupatha Division Irrigation Gulaghat. The date for submission of the bid was on 7/8/2023. It is the case of the petitioner in the instant proceedings. That the invitation was open in respect to the second tender issued on 15/7/2023 to all registered bidders, class 1, bracket A, B, and C, bracket close, contractors oblique firms of the irrigation department having experience in similar nature works. The qualifications as well as the eligibility of the bidder was duly mentioned in the notice inviting in section 2, section 1 of the notice inviting tender, that is the instruction to the bidders. It is the case of the petitioner that on account of certain conspiracy, it is the allegation of the petitioner that on account of certain conspiracy between the respondent number 5 along with the respondent number 7, the contract was granted in favor of the respondent number 7. Which goes very much against the settled principles of law. It is alleged that the respondent number 5 have violated, have violated the provisions, various provisions of the Indian Penal Code. And as such, proceedings should be initiated against the respondent number 5, along with the respondent number 7. It is, however, very pertinent to mention that neither in WPC number 41585/2023 nor in WPC number 6431/2023, the petitioner challenged the work orders issued in favor of the private respondent in respect to both the contracts, both the notice inviting tenders, which were issued on 15/7/2023, as well as 14/8/2023. It is very pertinent to mention that admittedly the petitioner was in possession of both these work orders latest by 3/10/2023. The third writ petition so filed by the petitioner is WPC number 24, petitioner in person, is WPC number 2485/2024. Wherein the petitioner challenged the two work orders. The third petition. It is further pertinent to mention that this writ petition, being WPC number 6431/2023, was filed on 20/10/2023. And by an order dated 6/11/2023, while issuing notice the maintainability of the writ petition was kept open to be decided at the admission stage. The learned coordinate bench, by the order dated 6/11/2023, was even not inclined to issue notice upon the private respondent number 7. However, by an order dated 4/1/2024, the learned coordinate bench of this court issued notice upon the respondent number 7. No interim orders, however, were passed in WPC number 6431/2023, thereby staying the work orders. The third writ petition, which was filed by the petitioner in person, is WPC number 2485/2024. Whereby the petitioner sought for the first time cancellation of the two orders issued by the Superintendent Engineer Gauhati Circle Irrigation with immediate effect. Be that as it may, there is no mention whatsoever as to which are the two orders the petitioner sought for cancellation. The ground on which the third writ petition was filed was based upon the fact that the superintending engineer did not have the authority in terms with the Delegation of Financial Power Rules 2022 to issue the tenders in question. This court further takes note of that by an order dated 19/7/2024, notice was issued. However, there was no interim orders. First, this court have also taken notice of the fact that various miscellaneous applications have been filed by the petitioner in person, which have been registered and numbered as IA number 2817/2025, IA number 2401/2024, IA number 2073/2024, and IA number 2579/2024. I will hold it, 2581/2020. The question first arises as to whether the instant writ petitions are at all maintainable, inasmuch as the before deciding anything on merits, this court finds it very pertinent to take note of the maintainability of the writ petitions. Mr. N.N. Upadhyay, the learned standing counsel of the Irrigation Department, submits that the work orders which were issued on 15/7/2023 and 14/8/2023, the works have already been completed. Mr. D. Gogoi, the learned counsel who appears on behalf of the private respondent, submits that the works have been, all the works have been duly completed, but on account of the pendency of the writ petitions, the payments have not been made. This court have duly taken note of the qualifications which are necessary, the eligibility which are necessary in respect to both the tenderers. The eligibility which is required is that the bidder has to be a class 1 bracket A, B, C bracket close, class contractor, class 1 bracket A, B, C bracket close, contractor, registered with the Irrigation Department. This court inquired with the learned petitioner in person as to whether the petitioner in person is an eligible bidder. Eligible?
I was eligible, but condition was.
No, as on that date, were you eligible? Are you a class 1 ABC?
I was class 1A.
Show us the document that as on 2022-23 you were.
That point of time, my renewal has not been happened. No,
The learned counsel appearing on behalf of the petitioner, the petitioner in person. On specific inquiry made by this court, tried to distract with the said query. Mr. N. Upadhyay, the learned standing counsel of the Irrigation Department, on the other hand, placed before this court a communication issued by the on 27/8/2025, issued by the Chief Engineer Irrigation, wherein it was mentioned that the petitioner in person was a registered class 1A contractor under the Irrigation Department, and his registration was valid as an individual contractor for the financial year 2021-22. His registration was valid up to 31/3/2022. The petitioner in person, however, did not renew his registration for the financial year 2022-23 and 2023-24. Subsequently, in the financial year 2024-25, the petitioner converted his registration to operate as a firm under the name of MS PKB International Proprietor, Poros Kumar Bhattacharjee, inverted comma close, and that registration was valid till 31/3/2025. The said communication is kept on record and marked with the letter X. From the above, it is therefore clear that the petitioner herein was not an eligible bidder to both the tenders in question. In this regard, this court finds it very relevant to take note of the judgment of the Supreme Court in the case of IVR Ronak International versus 1999, 1 SCC page 494, wherein the Supreme Court categorically observed that an ineligible bidder cannot challenge the allotment of a contract. Let this court, apart from the above, let this court further take note of Mr. D. Gogoi. Just find out that name, IBR Ronak International versus 19. I think the citation is 1999, 1 SCC, page 494. 492. What is the full name? Apart from the above, this court further finds it relevant to take note of that in all the three petitions, there is no challenge to the notice inviting tenders, nor there is a challenge to the work orders in question. Apart from that, it is also apparent from the materials on record that the work in question have been completed, and there is no denial to that aspect by the petitioner in person. Considering the above, it is the opinion of this court that the three petitions so filed before this court are nothing but a clear abuse of the process of the court, for which the petition stands dismissed. This court would have otherwise thought of imposing exemplary costs upon the petitioner, but the taking into account that it is the petitioner in person who has appeared, this court restrains itself from imposing such costs. With petition, also with petition stands dismissed. Huh?
Not your IA part is given.
I closed. I stands
But
closed.
I may be given a liberty, but there's an impleadment party. Impleadment, private responsibility was impleaded.
All IAs closed in view of the. In fact, if I was the person earlier, I would not have. But Mr. Bhattacharjee, be careful, huh? This time we are putting a warning. Next time it again comes back to me, another matter of this type. You have to be, you see, you need to, you all are always present when your matters are there. Earlier also there were certain matters where I have disposed it of. When you are filing your petition, you should know how to file your petition. Be careful next time. This time, and if you are not there, you have to ask or consult a lawyer. You don't do it in this manner.
But there is not good.
There is no case now. Mr. Das, do something good in this matter. The process server and the driver, they are married. So one is you are putting somewhere in SEPA, the other one you are putting in UPF. Put them together somewhere. They have submitted a representation, ask the Registrar General to look at it. Newly married. Newly married. Ah, married. They are married. There's no quarrel with that. They are married. The Registrar General can very well. Like in the earlier case, I did not impose costs on the ground that He's a petitioner in person. We have to become a bit lenient when it comes from Arunachal bench.
Or it's also been where.
Issue notice making it returnable on 18th of June 2026. Mr. H.K. Das accepts notice on behalf of the respondent number 1. And Ms. So-and-so accepts notice on behalf of the respondent number 2. The petitioners herein extra copies of the writ petition be served upon them by tomorrow. You got a copy? No.
My brother can give a soft copy that will also, or he can send it to the registry.
The extra copy of to Madam So-and-so, her name, you put her name, be served during the course of the day. As regards the copy to be served upon the petition, the respondent number 1, the registry is directed to make a photocopy of the writ petition and provide a copy to Mr. H.K. Das by tomorrow, within 2 days. The petitioners herein are husband and wife. The petitioner number 1, who is the husband, is working as a driver in the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division UPIA in the district of Papunpare, Arunachal Pradesh, as a process server. Whereas the petitioner number 2 is a driver, whereas the petitioner number 2 is working as a process server in the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division Changlang in the district of Changlang, Arunachal Pradesh. The petitioner number 1 was transferred by the notification dated 8/2/2019 from the Court of the Chief Judicial Magistrate Civil Judge Senior Division SEPA, East Kameng District, to the Court of the Civil Judge, Court of the Chief Judicial Magistrate Civil Judge Senior Division UPIA by an order dated 8/2/2019. On the other hand, the petitioner number 2 was temporarily appointed as a process server by the order dated 5/2/2019 in the Court of the Judicial Magistrate First Class, cum Civil Judge Junior Division Changlang. And since her appointment, she has been discharging her duties with utmost sincerity. It is also pertinent to mention that there is a transfer policy for the staff of the subordinate courts in the Arunachal Pradesh, wherein, in terms with clause 11, if the spouse of the incumbent is also an employee of any of the 2 establishments, then they shall be accommodated in the same station provided vacancies are available. The petitioners have submitted, both the petitioners have jointly submitted representations on 1/11/2025. And the said representation have not been considered. And under such circumstances, the present writ petition has been filed. It is also the case of the petitioners that they have been blessed with a daughter in the year 2022 and a son on 11/3/2026. And both the petitioners are living apart on account of their jobs. The respondents herein are directed to bring on record their stand by filing the affidavits on or before. What is the date I fixed?
18/6.
I fixed it on 18. On or before 12th of June 2026. In the meantime, this court observes that the pendency of the instant writ petition shall not be a bar on the part of the respondent authorities to consider the representation submitted by the petitioners on 11/1/2011 or 1/11/2025, taking into account in the transfer policy for the staff of the subordinate courts in Arunachal Pradesh.
Highly over.
Yes.
My lord, the matter relates to issuance of IMFL license, my lord, to the petitioner. This petitioner, my lord, submitted their application, my lord, lordship kindly have a look at page 26, my lord. This format of application as well as the challan, my lord, page 29. 1 lakh at that time, my lord, in 2019 lordship, 14 to 2019 lordship. Then lordship kindly have a look, my lord, page 30, annexure B1. This recommendation of the district commissioner, my lord. 30th March 2022, my lord. Forwarding, my lord, I'm just reading. Forwarding application along with inquiry report for granting our IMFL on license in favor of Mrs. Pranita Kutum at number 2 Silagaon, Silapathar in Dhemaji district. With reference to the subject, so I have the honor to. Then it was recommended, my lord. Then again, these are the P2 are the inquiry report, my lord. Jointly, it was made by the superintendent of excise, my lord. Then lordship will find annexure C 33. It's a no objection certificate issued by the Gaon Panchayat, my lord. Since the wine shop is situated in rural areas, my lord. That is why Gaon Panchayat certificate is necessary. This annexure C. Now another recommendation, annexure D, my lord, of the district commissioner, my lord, as asked by the commissioner of excise, my lord. Again, inquiry has been made. Annexure D1. On the basis of the then, my lord, on the basis of the recommendation made by the district commissioner, lordship have a looked annexure F, page 39, my lord. Then we'll come to the complaint. First, lordship kindly see the annexure F, page 39. It was Commissioner of Excise, Assam, Houseway Complex, to the government, Commissioner Secretary, Government of Assam, Excise Department, my lord. Application for of Mrs. Pranita Kutum for grant of SOSO. Government letter number so cert. My lord, this is important, my lord. I want to read. When it was forwarded recommended and forwarded to the government of Assam. This letter is pending before the government as on today. Meanwhile, this objection, this complaint has been filed by some of the persons who are beyond the side of this petitioners. The false complaint has been made.
So with the complaint being there,
Yes.
then how can you be?
No, complaint is, my lord, they have stated the wrong things, my lord. Because here they have said that Nipin Kutum's wife. I'm not the Nipin Kutum's wife.
But they have an objection. You see, as per 295, if there a person is there, if he wants to have, if there is one objection also, there is gone.
My lord,
Because you don't have a right.
that thereafter, my lord, I have no, my lord, lordship kindly hear me.
Privilege.
No, thereafter we have filed a clarification, my lord. Then, my lord, there is a inquiry report again.
I've seen it, seen all the
No,
people.
inquiry report, kindly have a look, my lord. This page H, lord.
Page?
H, annexure H, page 42, my lord.
Kindly come to page 53.
Lordship,
This is the last of the inquiry report. Page 53.
page
53.
yes, 53. My lord, that is why I'm reading, my lord, this page 53. Page 53, my lord, this is in my favor, my lord, this report.
Kindly come to page 54, the last paragraph.
Therefore, as per excise rules 295, there can be no bar to grant the license for the liquor shop at the said site because except Sri Vishnu Deka Bora and 16 others, excluding Srimati Ritu Sunwal, Sri Karan Sunwal and Salil Sunwal, who signed the objection letter, the residences of the other complainants are located beyond the 75 meters.
So, but there are some people out of 17, 15 people are objecting.
No, only 15 people are outside of the.
No. Because except Sri Vishnu Dekaburwa and 16 others, excluding so and so who signed the objection, the residents of other complainants.
No, except here, not except other, because except Sri Vishnu Purva, Deka Purva, Sunwal, who signed the objection letter, the residences of the other complainant are located beyond 75 meters. Well, Assamese version, probably lordship translation may be incorrect, my lord. Lastly, 56, lordship.
Then kindly come to the Assistant Commissioner Dhemaji's letter of Annexure L.
Yes.
That there is another IMFL shop within 75 meters of the proposed IMFL ops license site, namely Anima Bosumati's wine shop. There is also a private educational institution within 50 meters.
That private schools, my lord, this law is very clear, my lord, 289, my lord, section 289. Lordship aware about this, my lord.
What does it say?
I have stated in my petition, my lord, that one.
Where? Have they rejected?
No.
Or is it under consideration?
Even in 2026, I have paid another 1 lakh, my lord, as per the new rules, my lord. They have directed me to deposit the amount. Lastly, lordship will find 62. Pay 62.
When did you pay?
I have paid it
22/8/2025.
Yes.
No, wait.
No, my lord, since matter is, my lord, lordship kindly have a
If I
look.
dismiss the petition now, then it means then 1 lakh will also go.
Lordship, kindly have a look. This 289, the provisions, Your Lordship. Provisions, my lord, regarding educational institutions, my lord.
Okay. We'll issue a notice. We file your affidavit. Issue notice making it returnable on 24th of June 2026. Mr. N. Goswami accepts notice on behalf of the respondent numbers 1 to 7. Huh? Okay. No, we need all the excise people. The deputy commissioner acts as an excise authority only here. You don't come here, because you will be in problem. 1 to 7. Extra copies of the writ petition be served upon them during the course of, upon Mr. N. Goswami by tomorrow. The petitioner herein is aggrieved by the non-issuance of an IMFL on license, on or off, IMFL off license to the petitioner, in spite of the fact that the petitioner had made an application as far back as on
14 to 19,
14 to 2019, and thereupon have been pursuing, and thereupon various reports have been provided, thereby holding that the petitioner was eligible for the grant of the IMFL of license. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 19th of June 2026.
Yes, Your Lordship. Lordship, the respondent number 4 was supposed to file their affidavit.
Non-payment.
Non-payment of debtors.
No, there is no, if Lordship can go through the, there is nothing on record. What is the admitted amount? What is the total bill amount? Nothing, Lord. How much they have paid, they have been paid by the authority.
They are dismissed similar writ petitions.
Lordship, the affidavit of the respondent number 4 is necessary, Lordship.
Why?
Because respondent
Who
number
is paying for respondent? Yes, why you are not filing it? It's been leaved from 2022. Hello, let us see the face of the principal, na?
Lordship, because this is the principal who.
Let us see the face of the principal. It is saying that the instant writ petition was filed in the year 2022. And on various occasions, time has been sought for on behalf of the respondent number 4 to file affidavit. However, no affidavit has been filed. On the other hand, Ms. So-and-so who appears on behalf. No, respondent number 4. Wherever it is. Appearing on behalf of the respondent number 4 submits that upon seeking instructions, the respondent number 4 is not providing such instructions so that the affidavit could be filed. It is the opinion of this court that when a notice has been issued and the respondent number 4 appears before the court and have on various occasions taken time for filing the affidavit, thereby delayed the disposal of the writ petition, and now have not provided instructions, it appears that the action on the part of the respondent number 4 in not filing the affidavit appears to be undermining the rule of law. Considering the above, list this matter again on 1st of June 2026 at 10:30 a.m. The principal, Ting Kong College, shall be present through the video conferencing link to be provided by Ms. So-and-so to answer to the allegations made in the writ petition.
Lordship, I record our presence. I'm for the
All your names will be put.
made to the Lordship.
This case, in this case, I'm paying from Marcy Lordship. I'm supposed to.
Marcy?
Marcy, I'm fine.
What is this? You know one thing.
Yes, Lordship.
When Mr. H. Buragoy appears, there's no mercy. Yeah.
I'm fine. I'm supposed to record. Full record is not there. Record is also necessary. It's a interesting case, Lordship. Lordship may fix. I will file a affidavit. Lordship.
3 years have gone, madam, Mr.
Lordship.
Sharma.
Lordship, during this time, actually, record I got it. I somehow forgot it, Lordship. Lordship, for the last chance.
Forgetting would not help you. I can't help you. Forgetting.
Yeah.
Yes, Mr. Buragoy, argue.
Lordship, in that case also, in that case,
What is the case?
The matter before your Lordship, we are aggrieved by an order whereby the Assam Fishery Development Corporation has rejected my technical bid on a very flimsy ground and thereafter has awarded the settlement to the private respondent number 6. My lord, the grounds that they have raised was basically they are saying in the impugned order that previously I was the earlier settlement holder of this prior to this NIT, my lord. Previously, I was the settlement holder of the same fishery, wherein, my lord, I was awarded the settlement of the same fishery, but after awarding of the contract, my lord, I could not deposit an additional amount of rupees 11 lakhs and some odd figures as a bank guarantee, which they have apparently introduced, my lord, which was not in the NIT, just in order to adjust the security amount. They have apparently, by a corrigendum, they have made me to deposit 11 lakhs within a period of just 7 days. So I could not deposit 11 lakhs within 7 days, and ultimately they cancelled my earlier settlement just without even giving me the possession of that fishery. Now, my lord, in between, before cancellation, they floated the new tender, wherein, my lord, the current tender is in question, my lord, wherein I participated because my cancellation was over. After participating in the tender process, my lord, I was expecting that being eligible, they will basically follow the procedure and thereafter they will decide. I mean to say, my lord, the contract would be awarded to me because I was the highest valid bidder in the process. My technical bid, my lord, they did not consider, and in the impugned order, they are saying that because you in the earlier tender have failed to execute an agreement and pay this amount, so this current tender process also, we are cancelling it because in the earlier tender process, you have not been able to deposit the amount and the contract agreement was not executed, my lord. My lord, my earlier conduct or earlier failure to perform certain, my lord.
Where is the order?
Yes, my lord. At page 125, my lord. 126 is the relevant part, my lord. This bill is called Godador Bill in the district of Hubri, my lord. My lord, I'll take your lordship to the copy at page 123, my lord. I'm sorry, my lord. 123, my lord. The following 5 individual societies submitted the bid documents for the obtaining settlement of
What is your name?
My name is Thakurdas Burman, serial number 3, my lord. Serial number 3.
Following 2 individuals have submitted the bid.
Under NIT number 1, he was selected as H1 bidder for settlement. However, he did not execute agreement with AFDC and surrendered the settlement offer. Hence, he is found invalid for participation in next tender. This is vague, my lord. With all due respect, my lord. This cannot be a ground for rejecting my technical bid, my lord.
Disqualified under NIT number 1. Selected one for settlement, however, he did not execute the agreement. But hence he is found not worthy of participation in the case. Now, show me the terms and conditions of the agreement.
Yes, ma'am. Yes. Kindly, lordship may come. My lord may kindly come to the tendered documents, my lord.
Hmm?
My lord may come to page 57 is the NIT, 57. Then my lord may skip this. Just one thing I just wanted to
What
know.
are the terms?
Yes, my lord. The terms, relevant terms, my lord, would start from clause number 7, page 63. These are the technical.
Page 61.
63, my lord.
There is 61 are the qualifications.
Yes, ma'am. These are qualifications, my lord.
Submitted in view of the minimum price of.
The tender must be.
Tenders about the election.
I fulfill all these conditions, my lord.
Where are the disqualifications?
Yes, my lord. But before that, my lord, one aspect, my lord, page 63, if I may take a lordship to.
63.
63, my lord. But
Yes.
these are some documents wherein, my lord, the bidders are required to submit. If we fail to submit these documents at page 63 and 64, we are rendered, my lord, disqualified. So these are the fundamental documents we need to produce while scrutinizing my technical bid, my lord. So it is indeed not their case that I have failed to submit any of these documents, my lord.
No, is it a part of the disqualification?
A disqualification, my lord, they have not given any specific. Yes, my lord. One aspect is there, my lord. Let me take your lordship. Yes, my lord. Here. While clause number 11, my lord, at page 65. And page 66, clause number 12, my lord. (11.3) says, my lord, technical bids found in order in all respect will be considered for financial bid, my lord.
And I think 12 is for financial bid.
Financial bid, my lord.
So there is no bar if you have not paid.
My lord, yes, my lord,
If you have not paid the earlier or did not enter into the earlier agreement,
yes, my lord.
that is not a bar as per the terms and conditions of
Yes,
the contract.
That's
your case.
That cannot prevent me from being cancelled in the current tender process.
That is your case.
Yes,
So there is no bar.
There's no bar.
That the ground on which you have been rejected, there is no bar.
No.
Mr. Sharma, that's the case.
Yes, my lord. One more thing, sir.
You don't require an affidavit, but that is only the case.
That is only the case, but one aspect is there, though there is no bar. There is one bar is that lordship, we have issued settlement order to them in the earlier NIT number 1, lordship, in NIT number 1, and they have refused it, they have surrendered. For that, they have come to the court also. In the technical bit, they have come to the court and said that we have in the NIT number 1, we did not execute the agreement, so this NIT should be cancelled. Then lordship, here my assertion is that they are, as because they did not perform that part in the earlier agreement, they become the defaulter in one way.
Where?
No, not in another way.
No, Mr. You cannot bring a foreign condition.
Lordship,
It's the condition which is there in the NIT, you have to show us.
No, that foreign condition is not there, lordship. That is the case. But here, lordship, one more thing, lordship.
Hearing partly done, list the matter on Tuesday next for final disposal at 2 p.m. Records be produced by Mr. P. Sharma.
Item number
On 30, I got this.
Next Tuesday, 2 p.m.
On 30th April.
Huh?
No, I thought it is 30 April. Lordship.
No, why? What is the 30 April good about?
No, I have some problem, lordship.
Okay, on 30th April, 2 p.m. for
No,
disposal.
no, I have problem lot on 30th April.
You want, I am fixing it on 28, you have no problem.
No problem.
Okay, I'm fixing it on 2.
I'm obliged, my lord. Deeply obliged.
You answered only that question. Whether the rejection was on the basis of a term inclusive in the tender document. If it is beyond that, rejection is banned.
So I only verbal record.
Verbal serval would not do. Only thing, because you don't require an affidavit. That is the only issue.
Okay, I will.
Isn't it, Mr. Buragoy?
Yes. Yes, I will.
Yes, what is this?
Lord, we have challenged an award, Lord, passed by the labor court.
Award dated?
Award is dated 9/11/22. Sorry,
Is that award?
no, 39/22.
Page
It starts at, my lord,
166.
page number 166.
What is the reference?
Reference, my lord, he was removed
Let us
from
honor
the,
a workman is justified in
Yes.
termination by removal from the if not entitled to
yes.
so and so. Now, this is. So it's a case of reinstatement.
yes, with back wages.
Back wages. Now,
Below-
are you paying the 17B? Mr.
This was-
Dasgupta,
no,
you are
below-
getting the 17B?
No, my lord, that was not given by this honorable court because we filed an affidavit to show that she is gainfully employed.
You are gainfully employed now.
Yes. Oh, no, we filed an affidavit. Taking note of that only, my lord. that-
So an affidavit, no, have you filed a 17B application? Not filed. There? Rejected. Okay. So now the question is as to whether you are entitled for reinstatement or not.
With back wages.
Now, are you working? No.
No, I'm not. Yes, she is working, my lord.
Now.
She is very gainfully employed, my lord. She is a principal.
Huh?
She is a principal of a GNM training school, Nalbari.
Yes.
Kindly have a look at this.
No. Wait,
you have
Mr.
written it,
Mr. Chaudhary, I have passed an order. There is one thing.
Yes.
No, because, no, I remember this matter. Mr. KK Jain or somebody had appeared in this matter earlier. My order dated 1/11/2025. The instant petition has been filed as selling the award dated 39 passed by so and so, whereby there was a direction for reinstatement of the respondent number 2 along with back wages at 60% except for the period of her absence. It is also directed that the respondent would be for litigated costs. Mr. S. Das, the learned counsel appearing on behalf, submitted that in the meantime, the respondent number 2 is already working in another estate and does not intend to join the petitioner hospital. This is your submission. And why you are saying that about reinstatement and all? In view of the above, the only issue therefore raised is as to whether the respondent number herein would be entitled to 60% back wages for the period between the date of her removal and the date of the award, excluding the period of her absence and further to the litigation cost. It is also seen that the records are available, considering an attempt shall be made to be disposed of on 25/11. That's the issue. I remember, that is why I asked you about that thing. I remember this. Why the 17B was not. So therefore, we are going to only decide that aspect.
Yes.
And we are going to finish it off on next week. Because I fixed it. In fact, the bench got changed, I suppose. That is why. Okay. Oh, yeah, Mr. Chaudhary took time on that.
Look, it's the first week. You also kindly have it in the second week.
Okay, second week of May. Also, taking into account the order passed by this court on 1/11/2025 and the issue, which is the only issue which remains, more particularly identified at paragraph number 4 of the order dated 1/11/2025, comma, let this matter be listed on 12th of May 2026 at 2 p.m. for final disposal.
April.
Yes, 37. 36 file has not come. That is what you have been told.
See, I have received the.
I appear for respondent numbers 2, 3, and 4. I hope I'm audible.
What?
But sir, I have received a correspondent copy of the additional affidavit filed by the respondent on the one additional affidavit and joint affidavit. So let me.
My
go
lord,
through
I
this.
hope I'm audible, my lord.
Today
I'm
itself I have
appearing
received in the morning session.
Huh? You are appearing for Ankur Phukon. What is your
Am
case?
My lord, I hope I'm
Contractual
audible, my
bill,
lord.
I have been deprived from my legitimate amount, which I have asked, and in the meantime of doing pendency of the
So you
case,
want to file some reply or what?
yes, I want to look through this, what is there. I want to go through this.
The affidavit has been
You have
filed today,
filed-
Your Lordship. The respondent number 234 filed the affidavit today, Your Lordship.
Okay, it has been submitted that no, some additional affidavit.
Yes, ma'am.
It has been submitted that the respondent number
My
2,
lord,
3, and
am I
4 has
audible, my
filed
lord?
an
I
additional
apologize.
affidavit today. The said additional affidavit is not in the records. List this matter again on 22nd of July 2026. In the meantime, the petitioner would be at liberty to file reply there against.
My lord, my lord, may I make a
It is
submission, my lord?
appearing
I
for
hope,
respondent number 234.
my lord, I hope I'm
Give
audible,
your-
my lord. I don't know if I'm audible. Am I audible, my lord?
Madam, can we produce the last order dated
Item
11/3/2026?
36. Okay, what
My
is
lord,
that?
am I audible?
This is a case where, my lord, the deputy commissioner has said that they have sent the original documents to the Panchayat commissioner. And the commissioner office said that we have not received. So thereafter, my lord, this honorable court has passed an order.
What is your case?
My lord,
What is your case?
my case is that I have doing some contract work in the
Then?
Panchayat election.
Due to the breakdown completion of the work in the health on the Okay. I passed a long order on
Yes, my lord, your lordship's order is there also.
28/7.
Yes.
Then now the thing is like this, there is a problem between the deputy commissioner and the
And the
PNRD department.
Commissioner of Panchayat.
Have you sorted out?
My lord, we have filed affidavit in this regard, my lord.
Ah.
The original documents, they have not produced, my lord.
Who?
The district commissioner, my lord.
Now district commissioner says that he has
But-
given long time back.
But no proof is there, my lord. We have not received the original one.
Then what to do? Then take his duplicate copies. Take the duplicate copies from him. You will submit duplicate
My
copies
lord,
and
if-
then process.
Can I suggest one thing? If district commissioner admits the bills, my lord, they can certify with the photocopy. In that case, the finance department will accept. Otherwise, without certification, they will not accept.
Okay, Mr. Borua. We do one thing. You will provide duplicate copies of the bills. And you have already certified that he is entitled to,
Yes.
because that is your stand. Now the question is, the commissioner PNRD is saying that we don't have documents. You have not sent it. You say that you have sent it. Because of your mistake or his mistake, he should not suffer. So therefore, he will submit the photocopy or duplicate copies of the bills, and you certify it and send it to them. PNRD, and we'll await updated instructions after 3 months. This court passed the following order. This court, by an order dated 28/7/2025, have categorically dealt with the present issue, present dispute. And passed the following order. That is following order. And passed certain directions. Paragraph number 2, 3, 4, 5, 6, and 7 being relevant are reproduced herein under. It is seen that in pursuance to the order dated 28/7/2025, the interdepartmental issues, the interdepartmental dispute as to whether the original bills were submitted by the Deputy Commissioner to the PNRD department. Still continues. It is the opinion of this court that from the stand which have been taken by the Deputy Commissioner, it is clear that the original bills were duly placed, were duly submitted by the petitioner. And the Deputy Commissioner thereupon had forwarded to the PNRD department. The amount of rupees 18,64,649 is duly admitted by the Deputy Commissioner. It further appears from hearing the learned counsels appearing on behalf of the PNRD as well as the district administration that on account of their interdepartmental disputes, the petitioner cannot get the benefit, would not be disbursed the amount to which the petitioner is entitled to. Under such circumstances, in the interest of justice, this court is of the opinion that certain directions are required to be passed. Accordingly, this court directs as hereinunder. The petitioner shall submit duplicate copies of the bills to the district commissioner, to the office, to the district commissioner, which one? South Salmara. Within 15 days from today. Upon receipt of the said bills, the Deputy Commissioner, District Commissioner South Salmara shall carry out the necessary verification and certify the same. Upon finding the same to be correct. Number 3, based upon certified duplicate bills, based upon the certified bills. Upon such certification, the District Commissioner, South Salmara, shall forward the same to the Commissioner PNRD. Next. Within 30 days from the date of submission of the duplicate bills by the petitioner. Based upon the certified duplicate bills to be forwarded by the District Commissioner South Salmara, the Commissioner PNRD department shall take necessary steps for release of the amount to which the petitioner is entitled to. The same be done within a further period of 60 days from the date the duplicate certified bills are received by the Commissioner's Central PNRD department. List the matter on 7th of September 2026 for an update.
Thereafter, Finance Department will.
I am not concerned with factors.
Because we can.
That I have given you enough time.
We can send the proposal within that time.
Whatever may be, you give an update. Once this is done, we take it up with the.
Yes.
Mr. R. Islam, do you know what you have done? Those applications, the contempt applications wherein you wanted to make the person, what the Commissioner and Secretary, General Administrative Department or Administration Department?
Administration.
Then what have you made in those applications? A General Administrative Department. So is there any general administrative department?
As per that, they have sent a letter by the duty commissioner, the general administrative department.
There cannot be general administrative. There has to be a general administration.
Yes.
Because of your fault, your application will go. Anyways, we have made the correction by ourselves. I said that, okay, Mr. R. Islam has the tendency of making mistakes. Okay, what is your case?
In this case, my only prayer would be that my father died on 1/8/1994. And thereafter I submitted an application for issuance of delay, for approval for delay, death certificate. And the department has now insisted upon for furnishing of cremation certificate. But at that time, my lord, when my father died.
You have filed the application before whom?
Online, online.
But this certificate has to be given to the has to be certified by the co-district commissioner and has to be given a particular approval giving reasons as to why it is given at a later stage. Thereupon it will go to the health department, they will issue it.
Yes.
But have you got that document? No. They are not taking up.
They are not taking up.
Why?
They have also sent the matter to the government.
Oh.
In such a situation, if cremation certificate is not
Who
available.
has filed the respondent number 4, 5 and 6 have filed some
They have
affidavit.
filed affidavit.
We have filed our affidavit.
What is it?
Also, we have stated that for if the time of death exceeds 1 year, then there is some order of magistrate is required.
Magistrate.
Yes. So for that purpose, Lordship, we have to submit certain documents. But in that process, Lordship, we have not submitted the cremation certificate.
Something.
Cremation certificate not available, my lord. We have stated, my lord, they are insisting upon for submission of doctor certificate. Because my father died at my home, so there is question of submission doctor certificate does not.
Get a doctor's certificate. But do something because the fact remains, Mr. Counsel.
Yes.
It looks very, it may be true for your case. But the fact I had the experience of dealing with a case where a person, Aadhaar card, the father has been shown to have been born. He was much alive in the year 1977 and in 1993. And this person was born in the year 86. And this person, after being born in 1986, whose father is there, all along it's okay. Then he moves the executive magistrate or the co-district commissioner and gets the delayed death certificate. The certificate, and then it is being given by the joint director of what you call the joint director of health service. They give it. Now later on, it came to learn that this person's date of birth is 86. And he got that certificate of his father's death on 77. Do you know why? Because a particular property was in question, which was acquisition. And the other party out here came out here and said that, look here, what has happened? There is a death certificate and therefore the sale is bad. This person sold it. So he said that my father was died. How can it be sold? In 77. So therefore, it looks very innocuous. Why not? But without giving that, how will they be satisfied?
In such cases, the assistant commissioner also written a letter to the government. If the particular person cannot submit the death certificate because his death was in our state, natural cause of death at home, and if there are no cremation certificate at that time, Nora Castle, area, there is no provision for issuance of any cremation certificate. And the Gambura also written twice that his father has that.
So why can't you take the Gambura certificate?
Lordship, that's why, Lordship, because the date took place in the year 1994.
And page
So we
53.
have page 53 of our affidavit, Lordship. We have sought clarification from the government, Lordship. In the light of that, therefore request to kindly.
From which government?
From the joint, we have written to the Joint Secretary, Health and Family Welfare.
You
Yes.
Madam,
Specifically, we have sought.
no, they cannot do that.
No,
You have
Lordship,
to take from I think from the revenue department, who is being authorized. The
No.
magistrate who is being authorized under one. It is
No,
the executive magistrate who has to give it.
Lordship, because Lordship, problem is that he has not submitted a cremation certificate. So we have sought.
Mr. Bolo, I understand.
Yes,
You see, normally they would issue the certificate. Okay,
yes.
but if it is more than 1 year delay, it is required from a certificate from the executive magistrate.
An order need to be passed, yes.
The order has to be given. There is a particular form. Which
Yes,
they
yes,
say.
yes, yes.
Once that is being given, then they will give it. Okay. Now that is the law. If that is the law, you are to therefore decide what are the materials, not on the basis of what the health department says. Health department cannot dictate. Health department can only issue provided you give the certificate. How are you going to say that? Because that is the mandate of law. Where is the registration of births and deaths? There is some act now. What is that?
Yes, yes. Registration of person dates like 1969.
There is. You take it up.
There is an order by 1/2/2026,
Huh?
2nd of February. Detailed order has been.
Because
passed by
that-
the
Lordship, yes.
So therefore, that particular thing has to be
Because
done by
that
you.
memorandum has been issued by the family department.
So, whatever may be the family welfare department, but they are to issue, they can only issue a subjecto. Just for example, tomorrow, if they say that, okay, the law says that, okay, you have to get an order from the court.
Yes, yes.
Is the court going to ask the health and family welfare department? No.
Here, Lordship, we just sought the
Kindly see
clarification
this provision.
whether the Gaon Pradhan certificate can be considered as the alternative document of the cremation certificate, Lordship. That clarification we have sought from the government, Lordship.
So therefore, you have to ask the revenue disaster management, not the health. You see why you are asking the person who is going to do it. Now let us see this particular provision. Death certificate, what is the provision?
Subsection 3 of section 13. Part and base, 1960.
Section, yes. Any birth or date of which delayed information is given to the register after 30 days, but within 1 year of its occurrence shall be registered only with a written permission of the district register or such authority on payment of such fee and on production of a self-assessed document in such form and manner as may be prescribed. Any birth or year which delayed information is given to the register after 1 year of its shall be registered only on an order of the district magistrate or a subdivision magistrate or by the executive authorized by the district magistrate having jurisdiction over the so and so. Now, it is for you to take a call.
Section 32 also, there is a provision for relaxation of rule in case of such a situation. If cremation
No, relaxation very difficult. Section?
32
No, it is to be by the government.
to remove the but admittedly, I do not have cremation certificate. I do not have doctor certificate. In such a situation, whether I.
For your, you take evidence.
Paragraph 6 of our affidavit.
No, not affidavit. You take evidence.
Therefore, Honorable directed the
And
government
on the basis of evidence, you decide that.
to obtain instruction.
Why you asking the health and family? Health and family welfare cannot say. Can you say that? No, they cannot say that.
No, we are just asking the guidance clarification.
Why?
Whether that Gaon Pradhan certificate can be substituted as the alternative document of the cremation certificate, Lordship. Because that portal, Lordship, that particular document has to be uploaded by the petitioner, applicant, Lordship. Because we are
Mr.
governed by
Bora,
the.
I think you are failing to understand what I am trying to say. But didn't we say that it is the district magistrate, executive magistrate, subdivisional magistrate who has to issue that document? And based upon the document, the register shall issue. Okay. Now, what you are trying to do is you are asking the register or the Department of the Health and Family Welfare. They have no business. You are to come to a decision on your own as to whether a case is made out for giving a death certificate, whether the reasons which have been assigned are justifiable for issuance of that delayed certificate or not. You may call in that proceedings anybody from the Health and Family Welfare Department and say, because you are exercising a quasi judicial power. You see that there is a difference. 13.2 is by anybody else. There's another person. If it is 1 month to, if more than 1 month, only see 13.2. 13.2 is by the given to the register after 13 days, so and so. It will be the district register's permission. So the Joint Director of Health Service can do it. 13.2 by giving reasons. There he can do it. But if it is more than that, the permission has to be given by you. By giving us an order to that effect, that look here, these are things we have looked into and found that yes, this is the reason why. You see, what is the reason? Shall be registered only on an order made by so and so having jurisdiction over the area where the birth had taken place, after verifying the correctness of the birth or death and on payment of such fee as may be prescribed. So therefore, it is for you to decide. You decide how it is your lookout and decide and pass the order. Once you pass the order, they will be bound. They are bound. So you have to pass an order. Now you are going to ask them. Don't try to give up your power. The Act is given a power recognizing you. Otherwise, you are asking an authority who is to act on your order what is required to be done. Would it be proper? My question is this. You take evidence. The issue involved in the instant proceedings pertains to issuance of a certificate by the district magistrate or the subdivisional magistrate or the executive magistrate in terms with section 13.3 of the Registration of Births and Deaths Act 1969. The legal counsel appearing on behalf of the district administration submits that they have sought for certain inputs from the Health and Family Welfare Department. This court have perused section 13.3 of the Registration of Births and Deaths Act 1969, and a perusal therefore would show that it is the district magistrate, oblique the subdivisional magistrate, oblique the executive magistrate who has to having the jurisdiction over the area where the birth or the death taken place to verify the correctness of the birth or death and thereupon issue the certificate, issue the order. Under such circumstances, this court directs the before whom? You have filed that application or not?
Yes, I have submitted application.
Before?
Online application, the online portal, basically.
Directs the respondent numbers 4, 5, and 6 to take effective steps for carrying out the necessary verification in terms with section 13.3 of the Act of 1969 within a period of 2 months to list this matter on 14th of September 2026 for an update.
Direction was on 2026 to verify whether my father died or not, getting correctness of verification of death.
That verification cannot be done like that. It is not on bail. You have to give evidence. If you fail to give evidence, you have to therefore call for an inquiry, ask him to give evidence. He may take oral evidence also. He may bring the Gauhati. You may cross-examine him and do it. You have to pass an order. Kindly appreciate. It is not a certificate. It is nothing to the effect. It's an order to be passed. And based upon your order, the moment you give that order, they will be bound immediately, they will.
Sort of it. Sort it.
What?
Little bit earlier, my lord. Teach them.
Little bit. Well, when did I fix it? 14 September. Chalo. We'll have it on 14 November. 14 September, good, because you have to give them time. We will ask you and produce evidence. It is not that it's so easy. Other line the pendency of the instant with petition shall not be a bar to pass the order by the as conceptualized under section 13(3) of the Act of 1969, and thereupon for the Health and Family Welfare Department to issue the certificate upon duly satisfied. Yes, what is this? SR Mother Bhuya.
Lordship, we have filed our affidavit, my lord. Lordship, I have a simple prayer, my lord.
They're entitled to the money.
No, my lord. We have not issued any work order.
Huh?
Other work order we have issued and all payment has been made, but no work. In the alleged payment, we have not.
We have denied it.
denied.
Lordship, we need to file our reply, Lordship.
Huh?
We need to file our reply, Lordship.
Okay. Ms. So-and-so appearing on behalf of the petitioner submits that the petitioner that the respondent number 2 have filed the affidavit in opposition only on 30/3/2026. And as such, the petitioner would like to file a reply. List this matter again on 22nd of June 2026. In the meantime, the reply be filed.
Lordship, I have a prayer, my lord. In the first date of listing, Lordship, one of my colleagues has appeared and he accept notice for all the respondent. I'm appearing on behalf of 1, 2, 3, and 4, my lord. 5 is the private respondent. My lord, may kindly notice may go, my lord.
When so appears for respondent numbers 1 to 4.
God bless you. God bless you.
Mr. Ghosh, your matter is not over.
Not over, my lord. Perhaps lordship may would like to take it because
What has happened?
order is we have challenged the again retender notice, my lord, because despite of pendency before the division bench, but
Somebody must have heard it. There is a long. What
Yes.
happened to the other 2 matters?
my lord, because I'm not aware of this, but I am concerned. I do not know whether they have filed in a writ appeal or not. We preferred a writ appeal, my lord.
Huh?
In the writ appeal, order was passed, my lord.
Isn't it this the same case?
Yes, three cases.
Where I
taken
passed
together.
certain orders.
3 cases are to be taken together.
Ah.
The lordship may kindly page 80, 87, 89. Lordship's order is page 47. That was carried.
Then?
Then it was carried to the division bench. My lord. So
Ah.
division bench order, lordship will find at page 87. my lord. In eyes also, my lord, they are directed to submit the site visit certificate. They did
What
not
did the division bench pass?
pass 87 lordship.
Huh?
The first order 87, my page 87. 7, 11, 25. One.
Then what happened?
Then, my lord, we are allowed to participate in a retender, my lord. But
So there was a retender.
retender, we are allowed to participate by the division bench subject to our right in this ret appeal. Then, my lord, they did not issue the site visit certificate, which is mandated by this NIT, my lord. So again, we approached to a interlocutory application before this honorable court. This honorable court directed them to submit. Till then,
Thereafter also they did not submit, my lord. Now that, my lord, lordship will find. Accordingly, my lord, when they did not submit the statement, my lord, we then file another interim application, IA, my lord. That order lordship will find its page 112, my lord. Page 112. Because at that time, they did not inform us that they have cancelled that second retender also, my lord. Rather, they said they have extended the time. In view of that, this honorable court has allowed us the time, 112.
Now, why this repetition?
Now, this petition against that cancellation, my lord. When they came to know that they have cancelled the second retender notice also, my lord, we assailed it. That, my lord, will find that page 119 and 120.
Now, what has happened to the appeal?
Appeal is still pending, my lord. They are supposed to file the affidavit. They did not file an affidavit. Court directed them to file an affidavit.
Now, what they have done?
Now, my lord, there is an interim order operating not to proceed by this in this writ petition law. In this writ petition motion.
Who are the parties who have applied? So you are challenging the 1712?
Yes, yes.
Why?
1712. That is a, my lord, second cancellation notice as well as the return notice of, my lord, 1812.
But here, what is the status? Was technical bid opened?
My lord, here, my lord.
In the second tender?
Second tender, nothing, my lord. No technical bid, nothing has been, no instruction, nothing.
Well, that part I can't say because there is an interim order operating, but my lord, so far as the site visit certificate was concerned, the earlier tender, my lord, it was issued, the petitioner did not turn up to collect it. That is what my instruction says. And accordingly, my lord, we have extended the date also, my lord. Even then, my lord, when the petitioner did not come, in the fresh tender, my lord, we were waiting. By the time, my lord, the last date of submission of bid was offered, when the report with the court.
Then?
Thereafter, there is an interim, my lord, not to proceed.
No. Now, again, you have cancelled it.
Yes, yes. New tender process. It's under call.
Where is the new tender process?
My lord, page 119, my lord.
It is, my lord, 17.
119 is cancellation.
Yes, 1812, my lord.
Now, 1812, another tender has been issued.
Yes, my lord. Despite of pending on pendency of this writ petition.
Huh?
That writ appeal, my lord.
So?
The writ appeal was, my lord, pending. So, my lord, their instruction was that in this writ appeal, my lord, they said that date for, my lord, submission of tender in the second NIT has been extended. Lordship will kindly see page 112. Lordship will say order passed by the court.
Understood. You see, if I understand correctly, this was a case where the PWD department, whenever they find somebody is not right, they adopt new measures. The case was in respect to Rana Construction case, which was there. I think all these 4 petitions were taken up for final disposal. In Rana Construction's case, one bidder, in spite of not submitting the particular documents, which will show what is the present, what you call the present liability, present ongoing works, that particular person was allowed and was held to be technically liable.
Otherwise, discounted on that one.
Then Rana Construction filed those cases where there was a stay. These were contracts pertaining to repairs. Now, in the meantime, while these matters were being heard by me when I was taking a bench for last year, one of the case was moved by Mr. What was his name? Earlier, Mr. Alam. This is the case where the case was filed, wherein, isn't it that case?
Yes.
Wherein, in respect to this work, you were held to be highest bidder, or the lowest bidder. Lowest bidder. And there were 2 persons who were the lowest bidder. They did not give for some time, and one fine day, they issued a notice to you.
Yes.
As regards this, and you submitted a reply or something to that effect. and said that these are the particular materials which were already, I think the authorities should have known about this or something to that effect, and thereupon held that although we have not mentioned all these things, but then also these materials were very much available. So under such circumstances, there they applied that criteria, that what is the pendency is there. So all these 4 petitions were taken up and disposed of. Now against that, you filed an appeal that without giving them an opportunity, there were various allegations, without giving them an opportunity to file a reply why this has happened. But the higher division bench, as I could see, although gave you, said that, okay, you can participate, do whatever you feel like, but there was no stay to that judgment.
Yes.
Judgment. Now, in the meantime, they cancelled the earlier, the new NIT was issued,
Yes.
where you again fought for the 7.1 certificate, site visit.
Yes, yes.
And after getting all these site visit certificates and all, now they cancel it.
Yes.
Isn't it? And therefore you come now here. My question is that in pursuance to the second tender, whether the technical bid was opened.
No.
So then what is your right?
Because my lord, the second bid, my lord.
I think you should go again before the division bench. We should dismiss it right away. What do you say, mister? Before the division bench. Because
we could not apply, my lord, in that.
understood.
Because
So
of
if it is, why you are, because of the fact that the matter is pending before the division bench, do you have a right to file a writ petition challenging the cancellation?
No, my lord, my
This is a case for imposition of
My lord,
cost.
my lord, we filed it.
At the end of the day, how much cost?
They did not issue us.
50,000.
Site visit certificate.
Today, I was about to impose a cost upon a person, but he was a petitioner in person. I did not. Now, because of this, I'm imposing a cost upon you. You take the burden. There is no conceivable right. Show me a right accrued on the basis of submission of the bid out there. Show me.
My lord, they did not assess by site visit certificates. We are unable. That is all may file a miscase before the division bench.
You file whatever matter before the division bench. I'm not concerned. But my question is, in pursuance to the second bid,
Yes, my lord.
the second tender,
Yes.
where is your right? And what stops them from doing another one unless a right is accrued?
My lord, this division bench allow us to participate.
So
the second.
So does it give you allowing you to participate? Does it mean that the state cannot cancel it?
I'm not saying on that. I am not.
That is the reason you are challenging.
No, my lord. They did not allow issue us a site visit certificate.
Understood, but that tender has been cancelled.
That tender, because in that tender, they cancelled the tender, but their instruction before this honorable court that extended time for that NIT, not
Whatever may be, you may be very hurt by your heart, but that doesn't mean that it has to, you have a right. That tender has been cancelled where no conceivable right have accrued.
Then this 112 order has been passed, my lord. Page 112. Lordship kindly see. On what basis?
What is that order?
Yes, Lordship kindly see. Page 130.
Yes.
Regarding the site visit certificate.
Yes.
Yes, Lordship will kindly see. How?
That the time for participation has perhaps expired and is incorrect in view of the submission made by Mr. Nath that the last date for filing the bid has
that
extended.
is regarding that earlier tender.
Understood. Which tender? That is the second.
This is not tender. This is not this tender. My 1812 now. It's not 1812.
Understood. That was the second tender.
Yes. Third tender. This is rather third tender.
Mr. Ghosh. First tender was which I held that your rejection was right. You went and first and filed an appeal. The learned division bench did not stay my order.
Yes.
No stay. But you allowed you to participate.
In the second tender.
In the second tender.
NIT.
Now in the second tender, you had a problem.
Yes.
Because the period was over and all.
The site visit certificate.
Where Mr. Nath had submitted that no, the period is extended.
Yes.
You got a site visit certificate.
Yes.
Pursuant to orders being passed by this court. After that, you participated.
No, because the time was over already. Second.
Okay.
Yes.
Now, very well. Now, you could not participate.
Because of not issuing on the side bidding certificate.
Okay, you could not participate.
Yes.
Now they cancelled that tender and issued another fresh tender. Now you can participate.
My lord,
Why are you asking for stay?
The entire matter is subject.
I think
Also, para 50, 11 and 12 what you of my instruction. That is what we are saying, madam. In fact, we have issued the certificate, but there is some delay. That's why to facilitate the petitioner, the entire tender process was cancelled. And it was retendered 11 and 12.
No, this is you are trying to play with the court. I think we impose a cost of 50,000. No, we impose a cost of 50,000.
Let them file an affidavit.
No,
my lord.
not necessary. What is your ground? You don't have a ground. You could not get a stay before the division bench as regards the second tender. You couldn't get a stay. Did you get a stay?
My lord, these.
No, Mr. Ghosh, tell me, did you get a stay?
No, my lord,
You did not get a stay.
I
Now,
did
in the second tender, you could not participate.
because of.
No, whatever may be.
Yes.
Now, in the third tender, which is being issued,
Yes.
you want to stay because of your matter in the division bench. That is the reason why. Isn't it a clear abuse of the process of the court?
No, my lord, this is the, because that,
Therefore-
my lord, we
No,
are under the impression.
Okay.
Extended time. When
Okay, you then do whatever may be. And this is not a case for this. Now, heard Mr. B.J. Ghosh, the learned counsel appearing on behalf.
Only next week, my lord.
No, now with the cost of 1 lakh now. This is an absolute abuse of the process of the court. Either withdraw, whatever may be. I cannot allow these type of things to be done. Heard Mr. B.J. Ghosh, now.
Tomorrow, my lord, on Monday, my lord.
No. 1 lakh is today. And by Monday at 2 o'clock, you deposit 50,000 to you and 50,000 to your client. Heard Mr. B.J. Ghosh, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned counsel appears on behalf of the respondent numbers 1 to 5. Full stop. The present petition has been filed by the petitioner challenging the notice inviting tender dated 18/12/2025 for issued by the Chief Engineer PWD HNE Assam for the balance work for construction of model secondary school in tea garden areas of Assam under RIDF-Roman 2028 at Akartipur Tea Estate in the district of Kachar. Pusto. The materials on record show the brief facts which led to the filing of the instant writ petition are that a notice inviting tender.
Not allowed to liberty to withdraw this.
Liberty? No liberty.
No, and withdraw.
Withdraw. Heard Mr. B.J. Ghosh, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned counsel, petitioner advocate general and standing counsel of the PWD department appears for the respondent numbers 1 to 5. The learned counsel appearing on behalf of the petitioner submits that the petitioner may be permitted to withdraw the instant writ petition. First, the petitioner further submits that the withdrawal of the instant petition should not affect the petitioner to participate in the new tender process. You want to participate or not?
My lord may give us a liberty there. The two parties.
No, I have to make your submissions here. Then only I can give you a liberty. that this should not affect the petitioner's right to participate in respect to the detailed tender notice inviting tender dated 18/12/2025 issued by the Chief Engineer, PWD HNE Assam for the balance work for construction of the Models Secondary School in Tea Garden area of Assam under RIDF-Roman 28 at Akartipur Tea State in the district of Kachar. Full stop. This court inquired with the learned counsel, learned additional advocate general, Assam.
It was 3/1/26.
Huh?
3/1/26 was the last date of submission of the
But was there a stay then?
State, my lord, it was state. Further purpose.
Tender notice was stayed, na?
Yes.
So therefore, he can participate.
The petition was preferred subsequent to that.
Then how can he participate?
So the expiry of the last one.
Okay, you extend the period.
That is considered lordship will keep the
Taking into account, this court have inquired with the additional advocate general as to whether the last date for submission of the bid is over or not. The learned counsel appearing on behalf of AR submitted that the last date for submission of the bid was on 19/12 on 29/12/2025.
Which was further extended till 3/1/26.
Which was further extended till 3/1/2026.
To facilitate the petitioner, that is what the instruction says, so that he can participate by collecting the site visit certificate from the office of the executive engineer. That he did not.
3/1/2026. Good. This court, however, takes note of that by an order dated 9/1/2026. Now, this court further takes note of that the instant writ petition was filed on 23/12/2025, but on account of the winter vacations, winter recess, the matter was listed before this court on 9/1/2026. Further to that, it is also seen that by an order dated 9/1/2026, this court directed that no further action be taken in pursuance to the impugned tender notice dated 18/12/2025. So, taking into account that the petitioner wishes to withdraw the instant writ petition, and more particularly to the challenge to the detailed notice inviting tender dated 18/12/2025, this court closes the instant writ petition on withdrawal. This court further observes and directs the respondent authorities to extend the period for submission of the bid by issuance of a corrigendum by 10 days, by 10 days from today. From 10 days from today.
From Monday.
Then I put it on Monday is, 10 days from, Monday would be 27, na? Issuing a corrigendum, thereby extending the period for submission of bid till 8th of May. 8th of May, full stop. The petitioner could be at liberty to apply, submit its bid in pursuance to the said detailed notice inviting tender dated 18/12/2025, if so advised. Interim orders, if any, stand before. Okay, this is the last item. I have to rise also today.
Respondent want to, we're supposed to file affidavit. Lordship, we have received the instruction, we'd like to file affidavit in this matter.
Mr. So-and-so appearing on behalf of the petitioner submits, a respondent submits that the instructions have been received and the affidavit will be filed within 3 weeks. List the matter on 8th of June 2026. In the meantime, the affidavit be filed on or before 3rd of June 2026. Yes, Mr. Mohanta, your last item. When do you want it? What is the urgency?
An interim order, since the writ petition is now pending. Initially the learned coordinate bands declined. Approach the division bands granted liberty to approach.
55 to do. Your item is 55, na?
55. Now, in view of the fact that here is a case, I am LOI declared. I deposited everything, and thereafter they reversed the clock, again went on digging into and declared me that my financial bid is flawed.
What?
Financial bid is flawed.
Fraud.
Flawed. Wrong. This is what they said ultimately.
Now, what is the coordinate bench do?
Coordinate bench said that I at page 17, Lordship may see. Page 17.
And what is your IA for?
IA for that seeking a direction that it would be they have gone for a fresh NIT. We want that it should be subject to the result of this decision of this honorable court.
We want an early date.
Or an early date for hearing. This the division bench granted us liberty in both.
We filed your reply.
I'll file it. Today it's come for the first time.
Affidavit in opposition filed by the
In the main writ petition I have, your lordship. The main writ petition.
No, that is not necessary.
Yes,
I know.
main writ petition I have.
What relief he is asking for, he can get the relief. He's just making a prayer only before this court. What relief you are asking in the IA, that relief you can get it in I will fix it. If it's so an urgency, I'll fix it on an early date. Take it as the top of the list and finish it off. There's no worry with that.
That can be done. What I want is that somehow otherwise my petition is going to be.
Mr. Mohanta, your junior counsel out there, he in the morning mentioned the matter to be taken up at 2 today. Thereby he was getting that order at the mentioned stage itself.
Probably, Lordship, he thought that Lordship will like to go through and find out what are the facts.
No, it's okay. The issue is simple.
Simple.
The issue is as to once an LOI has been issued.
Yes.
Whether it would amount to a concluded contract or not.
Yes.
Thereby going back to cancel it.
Yes. Yes.
But we will hear you on that date, on the next date whenever I'm fixing it. But the fact remains that whether fraud vitiates everything.
No, it's not fraud, my lord. Flawed. Wrong. Calculation wrong, they say. Not fraud.
We found that there was a lacuna in the calculation which they had provided in their financial bid. So the letter of intent was cancelled. There was no fraud. It was flawed.
Oh, flawed.
Flawed.
Flawed. Okay.
Yes.
Okay. It has been submitted by Mr. K.K. Mohanta, the learned senior counsel, that a matter requires an urgent disposal, taking into account that there is no interim directions passed by this court or even by the division bench in the instant proceedings. It is also seen that an affidavit in opposition has already been filed by the respondents. You don't want to file a reply?
We may file it in meanwhile. Tomorrow, day after.
Close tomorrow.
Monday, we file.
Mr. K.K. Mohanta submits that the affidavit in reply would be filed by Tuesday?
Yes.
By Tuesday. List this matter again on fifth of May at 2 p.m. for final disposal.
Well, I'm afraid by then they might go ahead with press settle.
You're settling
Yeah, we have issued a fresh tender process.
tender process.
Tender process.
And
Technical bids have been opened.
yeah, did you participate?
No,
And when are you opening the financial bid?
Lordship, perhaps because the model code of conduct, presently, perhaps we may not be able to proceed.
Okay. Taking into account that at present the model code of conduct continues to operate till 4th of May 2026, the respondents are directed not to take any action on the on the fresh tender which have been issued till the next date, that is on 5th of May 2026. Matter be shown as parted for final disposal.
Definition.
In view of the order passed in the writ petition, my eye stands closed.